Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. If you are new here, welcome. And if you have been here before, I've been rocking with your girl for a while, welcome back. Please do me a favor and hit that like button so that people know that we are having night court. We are going to chit chat about Sean Combs. And of course, we'll probably drift off to talk about something else that's going on in the YouTube streets, namely the YSL situation. We touched on it a little bit when it came to the allegation that attorney Bumpus is married to Shannon Stillwell. I was on the YouTube streets yesterday listening to all these platforms talking about it, and it is a whole hood mess. That should go over there to hood court. Now that might be something we bring over there to hood court with this whole Kayla Bumpus situation, because it's all over the place. But nonetheless, as you guys know, I went to Georgia and it was a whole bust. They're trying to be feet on the ground so that we can talk about this whole Ernest Williams situation. And they didn't have court. They didn't have it at all. And so I am just now coming in from flying home from Atlanta. And earlier, as I was getting different documents waiting at the airport, I did post in the membership different pleadings as it pertained to Sean Combs. And I also told the members I'm going to go live. So that is why I'm here this late, because I wanted to be a woman of my word and come on as I said that I would. Now, if you are not a member, go ahead and become a member. Go ahead and become a member. Basically, what you shall get on top of just supporting the platform, because you guys know that I go out and I report from different states and all of that. So your support helps with that. But also, sometimes I just don't have the time to go and do a full live. So just so you can be in the know, I drop documents in there to let you know what's going on certain cases, such as I think it was today, we had the I think I dropped something on Donald Trump that basically they don't know what to do. They're trying to ask the court to Jack Smith is trying to ask the court to just cancel all of the upcoming dates. We got to figure out what we're going to do and how we're going to proceed, which is AKA they're probably going to end up dropping everything. I mean, we know the indictments that he has not went to trial for, that they're probably going to end up dropping all of those anyway. So that was in there. And then I also gave a brief synopsis of what we will be talking about when it comes to Sean Combs. So for those of you that somehow have been hiding under a rock somewhere, Sean Combs is currently at the detention center and has been accused of a lot of heinous sexual crimes that remind you of various stories on SVU. I was watching Law and Order SVU, and it really sounds eerily similar to some of those situations that they were doing undercover stuff on SVU. But that's what they are accusing Sean Combs of, and he is trying his best to get up out of jail. So he has submitted a new proposed bond package, and of course, the government will respond, and then they will be presented in front of another judge. This will be a different judge that was assigned after the first judge had already denied his first request and second request. The first request was the magistrate; it got denied. Then he went to the judge that he's assigned to, because that's where you appeal from the magistrate. The judge was like, no, 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 no. And then this time, remember, he appealed it, but then when he got discovery, what Sean Combs' attorney is alleging is that there may have been some misrepresentation by the government, which contributed to the other court, the district court, denying bond. And now they got this new information from discovery, and they know they was exaggerating and they were omitting things, and that was the reason why the judge denied it. So this current judge may look at it and be like, nah, we're gonna go ahead and give him a bond, and that's what they're hoping for. So right now the appellate portion is being held off right now until he has the chance to go down to back to the district court and do a reconsideration. So we have that document on what he's alleging that's new, which to me didn't really look that new. I think he just has more evidence maybe to support what he was just arguing, because before he was arguing things, but he really didn't have the authority. And now he's saying, well, I got discovery now, so I have the authority for what I'm saying. And the government was basically exaggerating the hell out of all of this stuff. That's what he's arguing. Then we had the gag order situation, because he's like, listen, he got tired of that Courtney person and the lawyer coming out talking about you got tapes and you got books and memoirs and stuff. So he went to the court and said, listen, judge, he had already went to the court before asking for a gag order, but what he was doing was consistently, every time something came out in the news or people came out and talked, he would just file another letter with the court, letting them know, hey, this is still going on. Judge, we need you to do something about it. And the judge essentially was like, listen, there's certain rules and responsibilities, professional responsibility, and certain rules under our federal procedures that has to do with the agents and has to do with the attorneys, and that the court expects everyone to follow those rules. And if you don't follow the rules, there'll be the consequences and punishments for it. I mean, that's all I can give you, okay? So he basically denied that gag order, and we have that as well. And I think that's a summary of what we're going to go over today. Let me check over here and see who is over here this late. Andrew, good to see you. Said came on just in time, just leaving my son's playoff game. We're headed to the second round. Shout out to your son and congratulations to him and his team. I hope you guys take it all the way. Tell them we're rooting for him. Yeah, it sounded like Granny the Great. It really sounded like I was watching the Law and Order SVU the other night, and it really sounded real similar to the Diddy situation. I was like, man, because their stories are loosely based off of stuff, but this was really an old like SVU, so it was interesting. See, and that was another thing. Okay, so Fine 9JA basically said what some people are wondering, because said, don't worry, Diddy, Orange will get you out. Some people have made those speculations like, wouldn't that be something if he lets him out? Wouldn't that be something? So we gonna see, because we know that Trump has no problem letting folk up out of prison. He don't care what y'all think of him. He's not a political person. He's already mad at this whole judicial system because he feels like it's corrupt because they were coming after him. And I think he is. Some people are going to get pardons and commutations. I told you guys, if he became president, my firm was going to switch, and I was going to be a pardon and commutation chick. I was going to be, can I get a pardon? Can I get a pardon for them? Can I get a pardon for that? Can I commute their sentence? I mean, that is one thing that he's done, that he did with no problem, and he let out controversial people that other people would not let out before his term ended. So, yeah. So let's go ahead. There's a couple of hundred of you guys in here. Make sure you hit the like button. I know it's late. A lot of people are going to catch it on the replay. June's Poetry. Thank you so much for gifting 5 memberships. I appreciate you supporting the platform. Mom's the Boss has been a member for 7 whole months. Thank you so much for your support. She said, I was almost asleep, but Pam Esquire is on. I am woke now. Thank you so much. You can always catch the replay. I know it's 11:30, and I'm not going to say that I'm not going to be here long, because when I say it, it seems like I'm always here long. But I did really good last time that I said that, because I was cognizant, because people were like, yeah, she'll say she ain't going to be here long. She's going to be here for a long time. So we're going to see the way it goes. I am kind of tired too, so I don't know. We'll see how long this lasts. But I enjoy doing this with you guys, and I appreciate it. I really, really, really do. Did I miss anybody? James Payday, thank you for becoming a member. I appreciate that. Gwen, welcome to the Intellects. Thank you so much for becoming a member. You are one of our social media jurors now. So we appreciate the love and the support. God's grace is sufficient. What a name. That's what we need right now in times like these. Been a member for 7 months. Thank you so much. You said thanks for the night court session, Pam. Of course. Not you took the Ambien. It's Memphis said, I just took the damn Ambien. I'm here with y'all until I ain't. Well, I understand. So I thank you so much for the time that you spend with us. And, I'm sure that I'll be talking while you're asleep. You know what I'm saying? You're going to be like, is Pam on or not? And you doze off. So I'll be like still on when you go to sleep. But thank you so much for coming on. I appreciate that. So let's get into it. What are we going to talk about first? The gag order. Okay, let's get into this gag order. So as you guys know, you have Courtney. We talked about him for a while. He has Ariel Mitchell Kidd as his attorney, and he alleges that Kim Porter gave him the original book. He got the main book on his drive. He got the main manuscript. Whatever. And then he said he looked at some videos, but then as different, I haven't watched all of his interviews, but I have seen people that I guess they say they've caught him in things that don't seem to be true. But nonetheless, he'll say he knows Diddy, but he only knows Diddy from being in the music industry. He's saying he's mentioned Tupac, and he mentioned some other people or whatnot. So I don't really know the connection in real life, because I don't know if he knows. But he alleges why he got chosen, why he became the golden person to get chosen. I don't know, but he alleges he had this information. He decided to go on all these platforms. And once he got done going on the platforms, the feds was like, hello? Hello? Yeah, you. We're going to need you to go before the grand jury. So he's told to go he went before the grand jury. And then apparently he was, that was me knocking, if that's what you came up here for. Okay. My son ran up here like somebody was at the door at 11:40. But anyway. So, I'm extra with all of the stuff that I do, son. I mean, goodness. So anyway, apparently now they want him to come back to the grand jury, according to his lawyer, to try to clean up some stuff. I don't know, but he's supposed to go back. But nonetheless, because of him going around, he kind of added to Diddy asking for a gag order, and that he's, basically he can't get a fair trial. He was like, listen, I can't get a fair trial, with all of this going on or whatever or not. So judge, I need you to stop this. Like, use your power, and I need you to stop this. Well, the judge on today, on November 8th of 2024, said basically absolutely not. You got other things that you can do in order to stop this or to try to help prevent any potential prejudice, but what you asking for, I'm not gonna do. So it starts out with the intro on all of this, on when he filed it. On October 20th of 2024, defendant Sean Combs moved for an order prohibiting prospective witnesses and their attorneys from making extrajudicial statements that he argues will substantially interfere with his right to a fair trial. In terms of who those, quote, prospective witnesses are, Combs clarified that the category includes, quote, all those who claim to be victims, end quote. The government opposed the victim gag order as, quote, extraordinary and beyond the purview, end quote, of Local Rule 23.1. And for the reasons below, the motion is, everybody put denied, put it in the chat. It's denied. Combs, and then the judge goes on to say, let me let you know why it's denied. Now, I done gave you a summary, so you don't have to be shocked at the end after you've read like 4 pages to know that I'm denying your stuff. I'm letting you know in the intro that your stuff is denied. And here's why. Combs authorities don't support a gag order applicable not only to trial participants, but also to any alleged victims and their lawyer. Local Rule 23.1 does not authorize this kind of relief. So you're using this rule as your authority, but that rule only pertains to witnesses and I think prospective witnesses and the parties. But anyway, the limitations on that rule don't even apply to witnesses, let alone prospective ones that haven't yet been identified. They certainly don't apply broadly to any alleged victims and their lawyers. Even Local Rule 23.1H, which allows the court to issue, quote, special orders, end quote, related to extrajudicial statements, only applies to, quote, parties and witnesses, end quote. So it only pertains to parties and witnesses. At this point, you don't know who the witnesses are. So you cannot just generally ask for a gag order on potential witnesses because the rule does not allow that. So basically, the court said you made that up, sir. You have no authority for what you're asking for. And to impose a special order, the court must consider whether it, quote, will be necessary to ensure an impartial jury and must find that other less extreme available remedies, singly or collectively, are not feasible or would not effectively mitigate the pretrial publicity and bring about a fair trial, end quote. Among the remedies that the court is required to consider are, quote, a searching voir dire, emphatic jury instructions, and sequestration of jurors, matters that Combs hasn't addressed. And we talked about that in the previous, one of the previous lives that I had. And we also talked about this when Ernest Williams was over in Georgia was trying to get a gag order. And it's the same thing. The state in Georgia argued pretty much the exact same thing, that there are other ways besides trying to violate someone's constitutional rights. That's an extreme measure. So before that, then you can voir dire, which means we're going to question the jury and see if they've been prejudiced in any way by what they've heard or what they think they know about Mr. Combs. So we can do that. We can do jury instructions that are very specific, that whatever you heard in the media is not evidence, don't consider it, or whatever other kind of special jury instructions that they come up with, or sequestration of jurors. So basically, it can be if the trial's going on. I think it was like O.J. Simpson, where they were staying in the hotel, so they didn't even have access to television, or they didn't have access to computers. But that seems more down the line because you really don't know who your jurors are right now. But there are various other ways of which you can try to avoid tainting a jury by pretrial publicity. And then they say a gag order under Rule 23.1H is an extreme remedy to be issued only as a last resort. And that's in U.S. v. Gotti. You know what? When you go to these New York cases, you get a whole lot of Gottis in a lot of these cases. Well, Combs 6 goes even further. Combs' Sixth Amendment authorities don't support his proposed order either. In Shepard v. Maxwell, the Supreme Court observed that the, quote, trial court might well have prescribed extrajudicial statements by any lawyer, party, witness, or court official which divulged prejudicial matters, but it did not indicate that blanket restrictions on potential witnesses, or even more broadly, all alleged victims, would be appropriate. So even the authority that you have given us, Mr. Combs, still does not allow you to try to put a blanket restriction on potential witnesses. I mean, witnesses that may or may not be even involved in this case. and also any alleged victims that you don't even know anything about. You don't even know who the victims are. The court only suggested that the trial court could, in appropriate cases, limit what the contending lawyers, the police, and witnesses may say to anyone. Combs' other sided authorities are similarly unhelpful. Your other authorities, they suck too. Each allows some restrictions on trial participants or the press, but says nothing about potential witnesses. And then it tells you all of the case law they use. The only decision Combs identifies that appears to involve a bar on speech by all potential witnesses is in U.S. v. Brown, and that's in the Fifth Circuit. Okay, that's not even over here. In that case, the district court imposed a, quote, gag order prohibiting parties, lawyers, and potential witnesses from making extrajudicial statements. While the Fifth Circuit upheld this order, it described the order as only affecting attorneys, parties, and witnesses. And its discussion of the constitutional considerations as state characterized the order as a, quote, restriction on the extrajudicial speech of all trial participants, end quote. The Brown court certainly did not address the sweeping First Amendment implications posed by a gag order applying to all alleged victims and their lawyers. But the Fourth Circuit in Ray Murphy Brown LLC, that's 2018 case, did. That case dealt with an order very similar to what Combs seeks here. Given the, quote, unclear yet extraordinary reach of the phrase, quote, potential witnesses, which cannot help but impair legitimate news gathering activities that in and of themselves underlie the proper function of the First Amendment, and assumes all covered individuals are identically situated pending and future litigations. The court rejected the order as, quote, exceeding what would be essential to the preservation of the trial. The Fourth Circuit was also skeptical about how the order would impact more than 20 cases that will be tried over a period of years, and how it treated lawyers no differently from parties who in turn were treated the same as potential witnesses. Just as in Murphy Brown, the requested order here is incredibly broad, treats potential witnesses identically to their lawyers, and impacts a series of ongoing cases. The court has an affirmative constitutional duty to ensure that Combs receives a fair trial. So they're like, yeah, we know we got a duty to make sure that your trial is fair. However, the essential Sixth Amendment requirement must be balanced with the protections of the First Amendment affords to those claiming to become victims, especially because prior restraints on speech are the most serious and the least tolerable infringement on the First Amendment rights. And we talked about prior restraints again on the Ernest Williams case. The authors of the Bill of Rights did not undertake to assign priorities as between First Amendment and Sixth Amendment rights, but the case law gives clues as to how to mediate between them when they come into conflict. For example, those who actively participate in a litigation may legitimately be subject to limitations on their speech, but the Supreme Court treats as significant the distinction between participants in litigation and strangers to it. Not all alleged victims will be participants in this case, and a blanket restriction on their speech will silence individuals who may never have anything to do with the proceedings here. And in any event, less restrictive alternatives must be considered and rejected before imposing a restraint on speech. Then they go to like cases that go for that proposition. To the extent Combs has a particular concern regarding statements made by attorneys for grand jury witnesses, so that is the Courtney situation. The court reminds counsel that the local rule clearly states, quote, with respect to a grand jury or other pending investigation of any criminal matter, a lawyer participating in or associated with the investigation, including lawyers for target subjects, witnesses, and in the investigation, shall refrain from making any extrajudicial statements if there is a substantial likelihood that the dissemination of that statement will interfere with a fair trial or otherwise prejudice the administration of justice. And that is the local criminal rule 23(1)B. As to statements by grand jury witnesses themselves, under Federal Rule of Criminal Procedure 6E sub 2, any grand jury witness may disclose publicly anything that occurred therein, including the questions asked of the witness and the answer given. So basically, he can talk if he wants to. That's what it sounds like to me under the law. Is that what it sounds like to y'all? Courts do have discretion to impose a reasonable obligation of secrecy on grand jury witnesses in any appropriate case. But if the courts want to restrict a little bit, I guess they can. But Combs has only raised statements in the media from a single grand jury witness. He hasn't made an adequate showing why a blanket gag order on all grand jury witnesses is warranted. So based on this, it sounds like with respect to a grand jury or other pending investigation of any criminal matter, a lawyer participating in or associated with the investigation shall refrain from making any statements if there is a substantial likelihood that the dissemination will interfere with a fair trial. However, it looks like a person that actually participated and testified as a grand jury, they have the right to disclose publicly anything that occurred, including the questions asked of the witness and the answers given. Now, what was interesting about the Courtney person is that he did say in one of the interviews that he felt like he was being interrogated, almost like he did something wrong. So I would be very interesting on what questions he asked, since apparently he can say what the questions were and the answers. I mean, would you guys, want to know? Because I want to know. So let's go on. When a case is a sensational one, tensions develop between the right of the accused to trial by an impartial jury and the rights guaranteed others by the First Amendment, but prominence does not necessarily produce prejudice. Every case of public interest is almost as a matter of necessity brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it, and who has not some impression of some opinion in respect to its merits. Balancing the interests at stake, the court has already taken steps to limit what can be said publicly, including issuing an order underscoring the requirements of Federal Rules of Criminal Procedure. So basically, she already entered the order reminding everybody what their responsibilities are under the rules and the local rules, and further requiring the government to make those requirements clear to anyone involved in this case. So told the government, tell your feds, tell your investigators, remind them of what the rules are. They can't just go around, giving, being the source to these newspapers, tell them what their responsibilities are. But the court said they are open to other tailored proposals that will help ensure a fair trial. As to the mounting civil cases against Combs, there are further steps that he can take, and they italicized the he, so they wanted to put emphasis on it, including seeking relief in particular cases if the parties or their lawyers have made prejudicial statements to the press. So basically, you can be asking in those civil cases that they not be allowed to talk in those cases, and then also, or you can move to stay the cases pending the resolution of this one, which I already told you guys I thought he was going to do. I thought he was going to stay all the civil cases, because it's not like he's going to sit there and any attorney that represents him is going to allow him to say anything in a deposition under oath. They're not going to allow him to participate in discovery, and he's the main person here. So because of that, you might as well stay. So I'm going to assume perhaps there's some strategy that they have of which they're not staying the cases. And perhaps that strategy may be, maybe we can try to get some of these civil cases dismissed, and we can sway the public perception by getting some of these cases dismissed, because now it's going to look like people are lying on him as well. And because of that, maybe we can sway. Because that's the only thing I could really think of right now, because I don't understand why they wouldn't immediately be staying these civil cases pending the criminal case outcome. But anyway, the judge let them know that is an option that they can try to do with their civil cases, just in case they needed a little bit of help. even though this judge is not involved in that at all. However, the unprecedented relief that Combs seeks on this motion is unwarranted, and the clerk of the court is respectfully directed to terminate the motion. Denied. So that is that. So what do you guys say? What do you guys have to say? Tatiana said, I'm glad the judge denied him. For Always Forever said, there's a thing called freedom of speech, so go sit down, Diddy. Yeah, a lot of people, they always trying to shut people up. And then a prior restraint is basically before I say, it's the difference if I say something that is prejudicial to you, like defamatory, and then you go try to file a motion, you file not a motion, but you go file a complaint against me for defamation, and you'll put the specific quote in there as to what I said that was defamatory. So that's a sentence that you don't want me to say anymore. But when you say I want to put a gag order, that means I can't talk to you ever, talk about you ever. That's a prior restraint. You cannot just stop me from talking because I have a freedom of speech under the Constitution in this here divided states of America. You know what I'm saying? So there's that. Judge, give me one more chance, Judge. One more chance. Judge, one more chance. One more chance. One more chance. Judge, give me one more chance. Somebody gonna come up with a song like that for real. What else? Let's see. What else we got in here before we move on to the next topic here? Allie said that's her on the table. They eating food off, and that's the party. Then okay, I clearly just was in the middle of that conversation because I don't even know what that's talking about. Okay, y'all ain't got nothing else to say. Nothing else to say about this. You over it? Y'all over the gag order? You over it? Okay. T Bam said, but wasn't he talking about how he can get away with it? Take that. Take that. Take that. Oh, goodness. Diddy cannot expect the court to silence people the way he did. Okay. All right, June's Poetry. That's a good point. There's allegations that he would threaten people like, do what I say. You hear me? Do what I say, or you won't work in this business ever in life. That's what they're alleging that he would do. And people were scared of him. And so, that's a good point. It's a good point. You guys. Empath VB said that's the problem. He like gagging people. Stay. I'm not ready for these comments. You guys are undefeated. I'm not ready for it. 70 years of an NDA. A lot, but see, I know there was an attorney that talked about the NDAs. NDAs are not uncommon. Y'all know that, right? Like with celebrities, it's not uncommon. They don't want you talking about their family, their friends, things in their homes, because you may be privy to personal life, and so they don't want you going to make money and sitting down and doing interviews or whatever. They don't want you to do that, so they'll try to do an NDA, but usually they do end. You know what I'm saying? Like they'll have it terminates after 5 years or something. But when you go to a party or do whatever, you're not thinking about, I'm going to go and tell what's going on in this party. A lot of people probably just happy that they were invited to the party. So NDAs are not necessarily, I'll be interested to see some of the clauses that's in there. Like you agree that everything you participated in was of your own volition and free will. Like, I wonder what the actual contract looked like. I'm gonna have to look at that. But I've seen that some people have released it according to some of the thumbnails that I've seen. I haven't really like read it at all, but not you saying the poor stuff. Tatiana said that's what he did to his lawyer when the Cassie tape came out, and CNN, he told his attorneys that she stole money. Oh, well, we're going to get into what he's alleging about Cassie, because there is I've seen some of the titles, and I think people are reading it. You know, everybody can read it how they choose to read it. I think that some people are reading it from a perspective that they just don't like Diddy, and Diddy is not my favorite person. However, I still can be objective. I'm not emotionally tied to the case where I can't look objectively from the legal standpoint. And basically, his attorney is saying, in a nutshell, as you will see in a few minutes when I pull the document up, is that the way the government was portraying some of these conversations and the relationship and the incident, because to me, it wasn't really new information that he gave. I think he just added authority to what he was saying, because he was saying this stuff, and even it sounded crazy to some of us. He would say some of this stuff to the judge when he was requesting a bond, but we kind of thought he was just using lawyer jargon. Like, you're just trying to make your client look good. And we're like, okay, that's, you're trying to, get your client out and, do your job and zealously defend your client. But now they're saying we have authority based on discovery for all the stuff that we were saying in this bond hearing. And now we want you, judge, to look at this with fresh eyes, because we don't believe the government, what they were saying was actually accurate. That's what they said. They said the government was not being honest. They called the government like straight up. They was like, y'all not being honest with what you said. And that's the reason why my client didn't get bond. So we want you to look at this. And then what happens is, if this judge chooses to deny bond himself, and they also added more to this bond package, which is going to be interesting. But if this judge chooses to deny it as well, then now they have this appeal being held. So now they can combine this denial with that and go to the Court of Appeals. That was their point of holding off on the Court of Appeals, because people were asking, like, why would they do that? I mean, what's the point of dismissing the case and then starting all over? Now you already have a case that's been filed. You already have a case number. It's been pending. Now, if you lose in this lower court again, in the district court, you can just combine them both and argue it together, both issues. And the court agreed. So that's why the court held off, which is interesting that the government fought that, because I didn't understand the basis for them fighting it. I figured the court was going to allow them to hold off, because that's judicial economy. You don't want to have, okay, we're going to dismiss this case, then we're going to start it all over, and then we're going to act like it's no point in doing all that. Just combine the cases. And that's what they did. But let's go with what they're talking about on here. See, we're moving pretty good. Make sure you guys hit that like button. So they start out the introduction. Mr. Sean Combs, through his counsel, renews his motion for release pending trial. This renewed motion is based on a significantly updated proposed bail package, new evidence, as well as changed circumstances regarding Mr. Combs' ability to prepare for trial while detained. So these are the reasonings why this should be revisited. First, Mr. Combs proposes an update bail package that is far more robust than the previous proposal, as well as other bail packages routinely approved by courts in this circuit. The proposed package even surpasses a bail package recently requested by the government in a comparable case in the neighboring district. You guys know who that is, right? That's that Abercrombie and Fitch guy. That's who you're talking about, I bet you. The updated proposed conditions, which include home detention with a strict 24/7 security monitoring arrangement and near total restriction on Mr. Combs' ability to contact individuals other than counsel, quote, will reasonably assure the appearance of Mr. Combs as required and the safety of any other person in the community. Second, new evidence received in discovery from the government undermines the primary basis on which the government initially sought and Judge Carter ordered detention. The evidence makes clear that the government's case is thin. It confirms the defense's initial description of the events depicted on the March 2016 video recording. The video is not evidence of coerced, quote, freak-offs, but rather minutes-long glimpses into a complex but decade-long consensual relationship between Mr. Combs and victim one. And we know victim one is Cassie. Additionally, the new evidence refutes the government's proffer at the initial hearing regarding a potential second alleged victim, and the new evidence confirms that the government's obstruction and witness tampering allegations at the initial bail hearing lacked a factual basis. That was just a professional way to say they weren't telling the truth. That's what they're saying. They're not telling the truth. Let's go on. Third, Mr. Combs' current conditions of confinement infringe his constitutional rights to participate in his defense. Given the government's amended estimate of the amount of discovery in this case and its unique format, including voluminous video and photographic evidence, Mr. Combs' release on the proposed condition is necessary so that he can review the discovery and prepare for trial. Despite the MDC's best efforts to facilitate the defense team's needs, the current arrangement makes trial preparation impossible, as evidenced by the recent multi-agency sweep of the facility and resulting lockdown. The Bail Reform Act and the Constitution demand more. Accordingly, Mr. Combs moves to reopen the prior detention decision and request release on the proposed updated conditions detailed within. So then they go over the court's authority. Okay, let's go to the proposed. You guys ready for this? This is the new proposed bond. Okay. For Always Forever said, can we please have hood court soon? Yes, we can. Thank you so much for the super chat. Yes, please hit that like button. Thank you. Thank you so much. We're up at midnight, okay? Please. Thank you so much. Now, this is the proposed bail package, and I want you guys to let me know if you think this is sufficient to ensure that Mr. Combs will bring his hind self to court, will not intimidate witnesses, and so that he can be out, so he can work with his team, so that he can vigorously fight these allegations. Because as he sits in that detention center right now, he is presumed innocent until found guilty beyond a reasonable doubt. So the defense proposes the following updated bail package, which will assuage any concerns of danger and obstruction and will ensure Mr. Combs' appearance in court. Okay, so a $50 million bond co-signed by Mr. Combs, his mother, his sister, the mother of his oldest daughter, the mother of his youngest daughter, and his 3 adult sons. So everybody almost in his orbit said, we will co-sign this. That if he, but we know his son, though, like, well, didn't his son get his car like repossessed or something? We know he ain't really got nothing to be backing anything up. But you know, I get where you're going with this. Your mother, sister, the mother of your oldest daughter. So that's like Chance, right? Is that the oldest daughter? The mother of the youngest daughter, that's Baby Love. She was just on there singing happy birthday to her dad. And then you had the 3 adult sons. One of them that couldn't pay his own car note, I think, allegedly. I don't know none of these people, so don't come for me. I'm just saying what was in the media. Secured by the equity in Mr. Combs' residence located in Miami, Florida. An encumbered property appraised at an unencumbered property. Remember, he paid it off. And it's appraised at $48 million. Now, I heard the house over there in California is up for sale and nobody wants to buy it. The one in California, the people was like, they heard all the stuff that was happening. And they in them houses, they was like, baby, ain't enough priests, ain't enough bishops, ain't enough apostles, it ain't enough pastors and ministers to go and anoint all these doors to make sure whatever was going on in this house ain't gonna jump on us. Because it's been on the market for like 2 months and nobody's interested. Nobody's interested. Would y'all like to live in a mansion of which Diddy lived? No? Yes? Huh? It's like they said ain't enough Bible. You can't put the NIV, King James, New English Version. You can't put what's the other? You can't put the one from Ethiopia. You can't use the one from Scientology, Jehovah Witness. None of these can help this house. So they having a problem. I don't feel sorry. My son was in MDC during COVID for 2.5 years, and he wasn't in there for nothing like Diddy, and they kept denying his bail. The lawyer did say it was hard to do legal visits. Wow. Why was he in there like, girl? I guess I'm getting in your business, but 2.5 years? Did he go to trial already? We need some more information for Always Forever, because that's crazy. Well, sometimes, in my opinion, I think even though bail is not supposed to be for punishment, it is supposed to make sure that you return and show up for court. And if you don't have money, unfortunately, this is where bond becomes racial a lot. People don't talk about it as much, but that's why you hear different urban type spots like Chicago that try to eliminate cash bond. And the reason why is because it's gonna be an obvious disparity. So like in my city where I was at one point, they had it where the judge, the way our court rules are, is when you plead guilty, you can be sentenced the same day. And if there's any fines assessed, you got to pay those fines the same day. So if you go there and you plead guilty and then they say your fine is $1,000, you got to pay it by the end of the day. Like they making you pay it at the end of the day. So if you didn't have it, literally the judge will keep you in court, have you go to the back and call whoever you can to try to get this money. Otherwise, by the end of the court day, you was going to the county. So of course that caused a difference that was obvious, because white people had the money and they would get out, but black people that didn't have the money, they was getting locked up. So it ended up being an ACLU situation. Turned out the judge got in trouble. It became a violation. So that is similar to what bond does. People, it's the have and the have nots. So if you have, you can get out. If you have not, you can't, because it's not supposed to be used for punishment. But sometimes what they'll do is they'll give you an amount that's almost impossible. Like, we got to give you bond, so we're going to give you $1 million even though you only got $200 in the bank, because we done all looked through all of your stuff. We done subpoenaed your whole life. We know you got $200 and we know you really don't have any family like that. So we're going to give you $1 million bond. The thing with Diddy is he got the money. He does have the money. So therefore, they were using things such as you're violent, is threats, coercion, what you're being accused of with these freak-offs. You threaten people, you drug people, you did things against your will. You are basically a danger to society. That's the primary, in my opinion, what they were trying to keep him locked up on. But Empath VB said, now come on, Cat. Come on now, cat. Come on now. Nobody want that. Nobody want that house. No, that's how Shannon comes. He like, come on, Ocho. Ocho. Ocho, don't you say that. Ocho, that's what they said. Ocho, that's what they said. Yes, he went last year, but because of COVID, they weren't going to court. A doggone shame. I'm sorry that happened to you. It's a shame because it's not bond is not supposed to be a way of punishment. Bond is not supposed to be a way of punishment, and even though it's not supposed to be used in that form, I do think that it gets used in that form, unfortunately. Because if I know that you ain't got it or your family don't have it, then I can keep you in here. So it's almost like that's why they give you credit for the time that you serve, because it's like you're presumed innocent until proven guilty beyond a reasonable doubt. But if I'm locked up, what does it look like? I'm being punished already, and you don't even know if I did it. You get why that's kind of conflicting, but then the courts have to assess. We don't want to let anybody out on the street, and then they go and they commit a more egregious crime. And then that falls back on the judge. They don't look at it like, well, to the public, they can't say, well, it's not used for punishment. It's just to ensure that they're going to return back to court. And I didn't think they were a menace to society. I didn't think that they were going to do anything, but that will affect a judge. That will affect their reelection. That'll affect the whole office of the office period if somebody comes out and does something even worse. So it's a balance that they have to assess. So let's go on. Yeah, sounds tricky. Reminds me of DV cases. Especially DV cases is like the poster child for that stuff, because you have DV cases where it's not as severe, and really they can go their own ways. One of them will lead the other one along. But then you got some people that are controlling, obsessive, and they're just psychotic. And so they don't care if they're on tether. They will cut that tether off, put it on their cat or whatever, and go after you because it's a control thing and they feel like they're losing control. So they will hurt you. And some people have ended up unalived because of it. So yeah, DVs are very, very tricky. Because a lot of times with first offenders, I know here they have it where you can get kind of on a diversion program. We have a specific statute where you can go to anger management and all of that type stuff, and then when you're finished they'll drop your charges. So that's like your first offense. So DV is not it's a misdemeanor, then it moves up to like felonies depending on what it is. So yeah, that is definitely a tricky situation. Good evening, Jonathan. Good to see you. Glad that you're up this late. Well, so the God's Earth said, I love how they gloss right over the defaced pows received during the raid. The problem with that is you also have to prove that it was his. That's a big house. He has a huge staff. And so you have to prove that. So the only one that they mentioned it, they definitely mentioned it. However, he has armed security. And some of the stuff that they found was connected to other people. So all he had to do is say it's not his. And how can they really prove that at this juncture, at this phase of what we're, apparently there was one that was taken apart in his closet or something. So they can try to connect it because it was his bedroom, apparently. But I think that was the problem that they went through, is that he has a huge staff and he also has a huge security detail. I heard a judge in chambers say in a DUI repeat offenders cases say, Mad will be on my doorstep if I don't give him time. Yes. That's why sometimes these organizations are important, because they can affect whether somebody is going to get reelected. That's how I used to be. The whole environment is different. The political environment is different. I don't even know if people care about what people think anymore. But yeah, they would let you know your name will be plastered on a billboard. This judge let him out and he got drunk, went behind the wheel and unalived somebody else. And this could have been prevented. So you are absolutely correct. But let's get into this bond thing. So full home detention at his residence in Miami or at a suitable location in New York with GPS monitoring. Counsel will travel to this location for any in-person meetings with Mr. Combs or have counsel meeting via video. To the extent Mr. Combs' travel is necessary to attend court or pre-approved medical appointments, his travel will be restricted to the Southern and Eastern District of New York and the Southern District of Florida. Mr. Combs must pay all or part of the cost of location monitoring. So we're not going to make the government foot the bill. He's going to do his own monitoring system. 24/7 monitoring by qualified security personnel approved by the government and pretrial services. They have a footnote as well that on October 24, 2024, the Second Circuit granted Mr. Combs' motion to hold his bail appeal in abeyance pending decision on the instant motion. We already talked about that. Thus, the appeal does not foreclose the relief requested here. Okay, number 4. Mr. Combs will have no access to telephone or the internet except for during calls with counsel to be arranged by security personnel. So he can't talk to nobody but his counsel. Restrict all visitors except for counsel and a pre-approved list only consisting of specific family members with the consent of pretrial services and the government. So he gonna be out and all he gonna do is see his family? So he said he gonna be celibate. He ain't gonna be nobody here but his family unless he mess around and marry somebody. What if he marries like Lil Love's mama or something? Because other than that, you just gonna have your family this whole time that you out. That's interesting. Family visits will be scheduled only with pretrial services prior approval. Security personnel will monitor the family visits. Okay. Mr. Combs shall avoid all contact directly and indirectly with any person who is or may be a victim or witness in the investigation or prosecution. Mr. Combs will consent to provide pretrial services random access to his residence. So they can just wake up in the middle of the night and be like, Mr. Combs, we are here to check you out. Mr. Combs' passport was surrendered to his counsel on April 1st of 2024, which counsel will provide to pretrial services. The following family members have also already surrendered their passports to counsel, who will provide them to pretrial. So Janice Combs, his mama, his Chance Combs, his oldest daughter, Jesse and Delilah, the twins, they done all gave up their passports. I thought he had baby Love on there before. I guess Love's mama like, don't stop me from going out the country because you got problems. Shoot, take my baby off the list. Counsel will continue efforts to sell Mr. Combs' airplane, so don't nobody even want to buy the plane. You know what? I was looking for an airplane. When I was sitting over there today in the airport, I was like, I really need a private plane that says the intellects on it, so I can fly from court case to court case. So maybe I should look into that. Maybe we could raise some money over here so I can go ahead and buy maybe we could raise some money and see if we can get something for the plane so that I can get to these court hearings more efficiently and fast. I think we can do it over here. I think we can do it. I think we're strong enough and we have the ability. I think we have the monetary power amongst all of us. And we can just go ahead and take this plane off of his hands. But then again, I have to get some people to pray over the windows and the doors and the seats. I don't know, it might be too much. I don't know. The intellect express. You see what I'm saying? You got to speak those things as if they were. That sounds good. That'll get us there. I don't got to worry about these delays because it was a delay today trying to leave Atlanta. It's always a delay. I could just hop on the plane. Oh, they got an emergency emergency hearing over there in Diddy's case. Let me hop on this plane and go head over there to New York. That would be very convenient. I'm just saying. Okay, let's continue. The defendant shall submit to testing for prohibited substances if required by the pretrial services office or supervising officer. He said, hell, I done been in detention for over a month and I ain't had no drug. Shoot. Y'all can test me now. I'm good. He said, I'm clean. Testing may be used with random frequency and may include urine testing, the wearing of a sweat patch, a remote alcohol testing system. He can't even have no Ciroc. You hear this? And or any form of prohibited substance screening or testing. The defendant must not obstruct, attempt to obstruct, or tamper with the efficiency and accuracy of prohibited substance screening or testing. Number 11, Mr. Combs must participate in a program or counseling if directed by the pretrial services office or supervising officer. So he's going to go get help too. Number 12, all other standard conditions of pretrial release. Additionally, for the avoidance of any doubt, and as stated during the September 18, 2024 hearing, quote, if Your Honor wants something more or different, we can do whatever Your Honor thinks is necessary regarding release conditions. Like, I done added all this stuff. I'm running out of ideas, Judge, but if you have any more ideas, he'll do that too. What do you want him to do? Wear black every day? Like, what do you want? What do you want him to do? Just take down his social media, period. Don't let nobody run it. What do you want? What do you want him to do? He's willing to do it. These proposed conditions present extremely substantial, comprehensive bail package for any defendant and are plainly sufficient to warrant pretrial release. For example, the Second Circuit affirmed the release on similar but far less restrictive conditions of a defendant charged in multiple counts, including drug trafficking, firearms, trafficking, and related offenses in United States v. Fox. Whoa. So there's a case apparently in the Second Circuit over there, United States v. Fox. Let me see. What's that case number? I wonder what happened to him. That's 2022. Is he still waiting an outcome? Let me look this case up right quick. Hold your horses. Hit that like button. This is why I don't ever say I'm just gonna was this in, I wonder if this was in the same, I know it's in the Second Circuit. I wonder if this was in, let me see if this was in the Southern District of New York. I'm just curious now. I just want to know what this guy, goodness, he got on, like, what was his bond packet though? Let me see if I can find it without taking up too much time. Fox v. United States v. Fox. I can't see it on here. That is very interesting, though. I thought he was going to mention Jeff and them, but I think he did because he said the Eastern District. So that's the Abercrombie and Fitch, but they said it's more than just him. Second Circuit. Let me find this page. United States v. Fox. Defendant James Fox is charged along with his co-defendant 13 count superseding indictment with drug and sex trafficking crimes. These charges arise out of the execution of a search warrant in the early morning hours of February 3rd, 2022. That was filed by a recorded interview of Fox and polygraph examinations. Oh, let me see. This was in the Western District. Western District of New York? Yeah, that's why I couldn't find it. Defendant James Fox is charged along with his co-defendant in a 13-count superseding indictment with drug and ex-trafficking crimes. These charges arise out of the execution of a search warrant at Fox's residence in the early morning hours of February 3rd, 2022, that was followed by recording interviews of Fox and polygraph examinations at the Lancaster Police Department. Wow. On February 3rd, 2022, at approximately 6 a.m., a search warrant signed by Magistrate Judge Michael J. Romer was executed at Fox's residence, a two-story duplex located in Cheektowaga, New York, on April 26, 2023. Hearing transcript. Because of information that Fox was known to be paranoid and paced the house with a shotgun while staring out the front window, the HSI Special Response Team participated in the search. Approximately 10 members of the SRT arrived at the residence in tactical vehicles known as Bearcat. Law enforcement entered the residence in tactical gear with their firearms drawn, shouting commands. They escorted Fox and co-defendant Rachel Delaval out of the residence. Oh, he had a co-defendant that was a chick too. While exiting the residence, Fox asked something to the effect of, quote, "We're going outside," end quote, and was told, quote, to shut the F up. At that time, the temperature was 27 degrees Fahrenheit. There was snow on the ground and the wind was blowing. Despite the weather condition, Fox was brought out of the residence wearing only his boxer shorts, oh my, and walked to the rear of the Bearcat in handcuffs and bare feet. The rear door of the Bearcat remained open to allow essays, Crumbles, and to observe Fox and Delaval. Despite the cold temperature and wind, which may have been blowing into the open door of the Bearcat, the rear of the vehicle had heat that was on during the ride. So basically, they had him shivering and cold, and this was like I'm trying to see before any subsequent Western District of New York. Okay, let me find this case on here. Now I know it's in the Western District, New York. Submit. Let's find you, James Fox. Sound like a common name. Okay, let's find you. USA v. Fox. This mug was just closed. Let's see. Detention hearing, order of detention. Let me see what this order says. Motion for the government. This first one should say he got remanded, though. Maybe he did another appeal or something. Let me see. Pull up his complaint. Let's pull up his complaint. Maybe that's not the same James Fox. Maybe it's this one. Let me see. Case summary. Yeah, this must be the one because I think it got another chick on there. Okay, let's see. Let's see. Controlled substance, sell and distribute controlled substances Ex trafficking of children or by force, fraud, or coercion. Oh my gosh. Wait a minute. Let's pull up this complaint. And he got out on bond? What in the what? Okay. I know y'all like, what is this girl doing? Between on or about January 2019. Let me pull this up for y'all so y'all can see what I'm looking at. I done moved on to somebody totally different. I was just curious at this case he was talking about. Did James P. Fox did knowingly, intentionally, and unlawfully rent, use, and or maintain a place that is the residence for the purpose of manufacturing, distributing, or using heroin and Schedule 1 controlled substance and cocaine and Schedule 2 controlled substance? Fact on February 2nd, Eurofine obtained a search and seizure warrant. Law enforcement executed search warrants. At the time, law enforcement entered the house. During the execution, law enforcement used the canine. Inside the bedroom closet and above the mentioned safe, law enforcement seized a loaded 20 gauge Remington model 870 shotgun loaded with 6 rounds of ammunition. They recovered 12 additional rounds of 20 gauge shotguns. On February 3rd, law enforcement conducted a video and audio recording interview. During the video and audio recorded, Fox was advised of his Miranda rights. During the interview, Fox admitted that the shotgun belonged to him, stating, "I got it on Black Friday a couple of years ago." During the interview, he admitted more than once in sum and substance to purchasing hundreds of dollars worth of heroin and crack and storing it at his residence so that he could redistribute the heroin and crack cocaine to prostitutes in exchange for commercial sex acts. Oh my. During the interview with law enforcement, Fox admitted twice in sum and substance that he knew that the prostitutes were all addicted to drugs and that he believed the sex acts couldn't truly be consensual since they were exchanging sex for drugs, which they were addicted to. What? He believed the sex acts couldn't truly be consensual since they were exchanging drugs, which they were addicted to. During the interview with law enforcement, Fox admitted in sum and substance that on 2 separate occasions, 2 different prostitutes had overdosed on heroin while at his residence and that he administered Narcan to both of them. Fox indicated that both these incidents occurred within the last 2 years. During the interview, after being asked why the shotgun was contained in the same safe where Fox had previously stored guns, Fox admitted that, "I mean, look at me. I'm not the type of person that's used to interacting with drug dealers and ish. I was rather worried about my safety. Eurofine is aware that individuals such as Fox who are involved in illegal possession, distribution, and controlled substances typically possess and or maintain ready access to firearms." Okay. While at the residence, law enforcement interviewed RD, Fox's girlfriend. RD stated in sum and substance that she had previously worked as an escort, that she initially met Fox when he paid her to engage in commercial X acts, and when she met Fox, she was addicted to heroin and crack, and that Fox offered to let her move into his residence. RD also stated in sum and substance that she eventually moved in with Fox, and after some time, Fox began supplying her with heroin and crack for her use at his residence. RD indicated in sum and substance that the last time she used heroin and her crack was August of 2021. During the search of the residence, law enforcement recovered additional evidence, including 1 plastic bag with suspected controlled substance residue, Narcan, 10 baseball bats with nails driven through the top, 1 large wooden X structure with affixed metal rings, chains, and ropes, 2 electrical tasers, and 1 stun gun with dischargeable cartridge. My. Oh my goodness. Okay. What? Okay, let me see what else. Let me see what his bond was. He told on his own self. Shoot. Oh, here's an actual indictment. Is that they use that indictment? Let me see. He got indicted with distribution of cocaine, using and maintaining drug-involved premises, possession of firearms and furtherance of drug trafficking, distribution of heroin causing serious bodily injury, sex trafficking by coercion, sex trafficking by coercion. So those what his initial indictment was. Then it sounded like they superseded it because he ended up with more. Dang, here's another indictment. Yeah, they superseded it and added more charges. Jeez, oh, Pete's. Where's this man's? Where's his determined initial appearance, detention here, order on detention. Oh man, oh man, oh man. Anyways, I digress. Let's get back to the matter, right? I was just intrigued. I needed to know. I need to know, like, what? You said he got out. Okay. So, United States v. Fox. Fox is just one of many cases concluding that such conditions are adequate. And United States v. Williams, that's a 2008 case, concluding similar conditions reasonably mitigate the danger to the community and risk of witness tampering. U.S. v. Sabani, describing comparable package as extraordinary and vacating and remanding for release in stated conditions. I wonder if, so let me see. So maybe they denied his motion or something. And then, they denied his detention and then they appealed it and he won that on appeal or something. United States v. Fox. Grand jury indicted. That's not the person. He got a lot of stuff he sent to the, he had an attorney that was working, because he got a few cases in here. Okay, let's move on. Because I'll be researching with y'all on her all night because I'm just that intrigued. Indeed, the government recently successfully requested pretrial release for two similarly situated defendants, including a CEO accused of trafficking dozens of young men, including through witness intimidation. So that's Jeffries. And I told you guys, and people was arguing with me saying that was he intimidating witnesses? Yes, this guy was accused of intimidating witnesses, and they still gave him bond of $10 million. In Jeffries, the government sought release despite claiming the defendants relied on the services of a security company to surveil and intimidate witnesses, thereby securing their silence. The conditions of release requested in Jeffries pale in comparison to the conditions proposed by Mr. Combs here. There, the government requested bond of $10 million and $500,000 respectively for the two released defendants and released to home detention with GPS monitoring. The requested conditions included no additional security or surveillance arrangements whatsoever. The conditions proposed here are more restrictive than in most of the other cases cited above. Mr. Combs would be in the custody of professional private security officers, whereas most of the cited cases impose only electronic monitoring or placing the defendant in the custody of a relative alone. The proposed security monitoring is precisely the situation contemplated by the statute. It specifies that conditions may include the defendant remaining in the custody of a designated person who is able reasonably to assure the judicial officer that the person will appear as required and will not pose a danger to the safety of any other person or the community. So that's that. So what do you guys think based on the information and how other cases and other jurisdictions have allowed, well, within the same jurisdiction actually, have allowed bond for greater offenses? What's your thoughts? Do you think that this bond package will secure Sean Diddy Combs to come back to courts? Do you think that? Ray said, I think he's still cooked. Okay. vote for said Donald finna get him out anyway. So we just talking right now. It's just content. Okay. I think a lot of people have said that. And the Jeffries thing did kind of throw me off because I was like, how he get out like that? And his is what's alleged with him is international. That's why one of the defendants, even though the government was going to allow him out on $500,000 bond, I think the court was like, hold on, time's out. He's not even a citizen of the United States of America. He can go back to the UK where he's from. And he still has ties to the UK. He's not a person that came to America and don't want to go back. Because you get people that come here that just don't ever want to go back to their home country. But he's actually spending time there and here. So they're like, no. So he's the only one that ended up being detained. That's the question for always forever. If Jeffries from Abercrombie and Fitch got a bond, what is the difference with Diddy? I get it. Y'all don't like him. But fair is fair. If you're going to show this happened with him, even though he's in the Eastern District of New York, Diddy is in the Southern District of New York, and this guy Fox was in the Western District of New York. So they all have different people, who run their districts. However, they're looking at the same factors for bonds, and they're coming up with different resolutions or different conclusions, which lets you know it's almost subjective. So that means what the judge feels, and if you can almost justify, like, I don't really like this cat like that, and I can justify this within the bond, I can deny it. Because what he's asking for is I don't need to talk to nobody but my lawyer. And then I do want to see my family, but I'm going to ask pretrial services first to approve it. And then we can have security when I'm talking to my family. They can listen to the whole conversation. Like, how more could and I'm on monitor. I'm on a tether that I got to pay for. So it does sound like he just wants to be able to adequately defend himself. So do you think that Diddy should get a bond based on this package? And also weighing other people that have done worse, allegedly, that were able to get bond. What y'all think? I want to see what happened to this guy because October 29th, did he plea or something? Let me see. Notice of appeal. So he's in an appeal right now in his Fox case, sentencing. Held on September 18 as to James P. Fox on his previous plea of guilty to count 6 of the superseding indictment. Defendant is sentenced to 360 months in the custody of the Bureau of Prisons, followed by 15 years of supervised release with conditions. So he pled guilty, it looks like, to one of the counts, and they hit him for real. 360 months. 360 months is 30 years. Whoa. And then once you get out 30 years from now, you got to be on supervised release for 15 years. Goodness, that's a lot. I hate to say it, but he should be entitled to a bond. That's just fair. See, this is what I'm saying. That's just fair. I get it. But it's the factors that people just aren't navigating through. I think they're just looking at all the allegations and they don't like them, But if you just look at the law and you look at the cases and you look at the pattern and what the judge, now we don't know Fox. We don't know some of these other people. So it's people that have done work. That's not to negate that what it's alleged that Diddy did, if it's proven to be true, that's not bad. But there is a difference between cases that are in the media and those that are not in the media. I have never heard of this Fox person, but you would entertain it. You may entertain it in that case, but you may not entertain it. And I don't know all the facts behind it. I'm just looking it up as we're on here. But Jeffries immediately got a bond. He didn't have to appeal. Jeffries immediately got a bond and did not have to appeal at all. So, and that was $10 million. And some people were like, but he's old and all of that. That's cool that he's old. However, so was Bill Cosby. They didn't care that Bill Cosby was old and losing his eyesight, did they? He was there with his PR person every day, holding his arm, walking up the court, tripping over cracks on the sidewalk. They didn't care. So I don't want to hear that whole, but he's old. Okay. Like I said, so was Bill Cosby. Yeah. So you said let's just revoke the other two. Well, you know, Fox got his time, so he got sentenced to like 30 years. So his been revoked, honey. That's true. R. Kelly, they may R. Kelly had multiple situations going on at the same time, too. How old was Epstein? That's a good question. Let's see. How old was Epstein? You think should none of them be out to make it fair? That's a perspective. How old was Epstein? He was 66. 66. Tracy said if he was more recognizable, do you think he would be in jail? I think if it was all of this, like Jeffries had a whole class action type lawsuit that's a quadrillion pages, but nobody's talking about it. Nobody's talking about him, period. Like, yeah, he was a CEO, but was he the face of anything? Did we see him like we see Diddy? Seen Diddy? Diddy was in every video. Diddy's been got the key. He's dramatic. He's on social media. He was doing vlogging. Like he really was. He wanted the fame and the money, and he wanted the face out there, and it has a consequence to it. But do you have millionaires that get indicted all the time? They do. They got way more money than Diddy and probably getting accused of worse stuff. But because we don't know them, they can successfully argue to get a bond until they get their day in court, and then half of them plead guilty to account, and drop the other ones. So I do think a lot of this has to do with the publicity surrounding it. Because if you can look up other cases where they're worse, quote unquote, the allegations are worse and they get bond entertained where they can get a bond, but then you can't, you have to look at what would be the reasoning for that. Because a judge doesn't want to look like they're being too lenient too. But I mean, federal judges have a lifetime position, so they don't have to worry about re-election. They're appointed by the president. That's another thing, Biden. We need you. It's 47 vacancies in the federal courts across this country. We need you to fulfill all 47 of them joints for the next 47 days. You need to get one at every vacancy. Fill every last one of them. Do not leave no vacancies open. Okay? Because we need some people that's a little less conservative up on these benches, because I like to do creative arguments, and I ain't gonna be able to do that with a bunch of conservatives in these federal courts. Okay? That's it. Veronica said Diddy is not being persecuted. 504 said, I know you see me in the video. True. Diddy was always over there like, you was gonna see Diddy was gonna make his way. You always seen Diddy. Ray Bishop said Biden need to get to work. He got less than 90 days. Okay, Biden. There's a few things I need you to do. First of all, I need you to get your pardon and commutation on. Okay, there are people that are in prison for weed that's doing life because of how the statute was back then. You need to get them all out. Just let them all go. You know what I'm saying? So we need you to fulfill these spots for these federal positions. Get you some former defense attorneys on these federal benches so we can have a chance. Okay, we need you to do that. Now, one thing I can say for Trump though is he do let people get out of prison. I said that. So he is like a part of the whole, and he's really gonna be, I think, a little bit more, well, a lot more vocal because now he's been through the system and he felt like he was wrong. You know what I'm saying? So that's one thing that he probably will do. But I need so we can get some better laws on the bench. You got to have better judges that think differently. You just have to. So I need Biden to get on his, get on his job before he leave up out of here. I need him. Don't sleep. The last time Biden was just doing his speech, he seemed a little bit more with it. I'm like, is it just me, or do Biden seem like he a little bit more, perky than normal? I guess knowing you about to retire and get up out of here, just like how George Bush Jr. was when he left, and he was like, I was like, yeah, that's a stressful job. He couldn't wait to get back to Texas and get back on his little plantation over there. Less than 60 days. Yeah, I wish he would cancel the student loans because I didn't even get a chance. Folks say he over there falling off bikes. Yeah, I didn't even get a chance to get, shoot. I have a couple of my family members got their debt eliminated from loans. So I'm happy for them. But yeah, I'm still over here paying. So anyway, then they go over the factors, and we're not about to even do that right now. So then they go over this alleged discovery, right? So then they say, the weight of the evidence in light of new evidence should be considered. So over the past 6 weeks, the defense has received approximately 23.5 terabytes of discovery material. That is a whole lot of discovery. The material reveals new information about the case, the evidence, and the government's previous bail contentions that was, quote, not known to the movement at the time of the hearing. The new material demonstrates that the government previously misrepresented the weight of the evidence, and it undermines the government's claim that Mr. Combs presents a danger. First, discovery includes blank. It's under seal. So even though they said it's new evidence, we won't even know what it is for real. I was over there looking like I'm about to, oh man, we're about to see what this new evidence is. No, we're not. So he's saying that blank refutes the government's core trafficking allegation. Second, this new discovery negates the government's claim at the initial detention hearing that there is a potential second victim. Third, the discovery shows the government's obstruction and witness tampering allegations were entirely misleading. And finally, the government failed to disclose to the court information concerning blank, we won't get to know, testimony that undermines its claims. We take each in turn. So there's a footnote that say, as of the date of this submission, a total of 7 civil lawsuits brought by plaintiffs' lawyers have alleged some form of sexual activity of a minor. While this is outside the criminal case and the subject of bail, let us be clear that these allegations are absolutely false. It bears repeating that the U.S. Attorney and scores of DHS agents have been investigating Mr. Combs for almost a full year, and there is no criminal charge of any conduct involving a minor. So for those of you that were believing these allegations about minors, he said he categorically denies this claim. So then we get a whole bunch of redaction that we can't see. Communications with blank corroborate the defense. As noted, the government's allegation of trafficking relate to one woman, referred to the indictment as alleged victim 1, with whom Mr. Combs shared an 11-year relationship. Included in the discovery materials are, guess who's not going to see it? Us. Guess who won't know what that information contains? Us, because it is under seal. They literally redacted it in here, and then they attached it under seal as the exhibits. That's you said it's only 2 words on that page. I thought we were gonna see this because they said it before. We have new evidence and all of this stuff. Nothing. You guys see that? Blank and more blank, blank and more blank, more blank and more blank and more blank. Blankety blank 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 blank. Blank 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 blank. Blank 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 blank. Bam. Then we finally get to some words, okay? So after all the stuff that we won't ever see, we have a paragraph, okay? The first mention of any ex trafficking or unwanted sexual contact involving alleged victim one was November of 2023, 5 years after the couple's 2018 breakup. So they're saying the first time that there's any mention of any trafficking was in basically this lawsuit that we know was filed by Cassie a year ago. And this was 5 years. They broke up in 2018. The evidence shows these allegations were merely attempts to obtain a financial windfall from Mr. Combs. So basically, she said this in her complaint. This is what they're saying. Y'all peep this. I want you guys to open up your mind. They are alleging that Cassie basically made this up so that she can get some money. But let's read further. In the spring of 2023, victim one revealed to one or more others that she needed money to support her small family. So apparently, she's told more than one person, and this must have been in the discovery, that she needed money to support her family. She told others that she had started writing a book about her relationship with Mr. Combs. In June of 23, she texted Mr. Combs' employee that Mr. Combs should contact his lawyer to have his lawyer speak with her lawyer. She followed up on this by a text on June 15th of 2023. That same day, her lawyer contacted one of Mr. Combs' lawyers who expected that she might make an extraordinary demand, recorded the conversation. During the approximately 8-minute recorded call, the lawyer confirmed that victim one, aka Cassie, was writing a tell-all type book and that Mr. Combs could buy the exclusive rights to the book for $30 million, which would ensure that it was not published. Mr. Combs and his lawyer considered that an extraordinary demand and did not pay the money. So Puffy told her basically to go to hell. Okay, I'm not paying you ish. So then in the fall of 2023, approximately 2 days before Thanksgiving, because I remember being one of the first to break that news, victim one, aka Cassie, pursued a different strategy. The Adult Survivors Act, which suspended the traditional statute of limitation for sexual assault claims, was scheduled to expire on November 24th of 2023. In November, victim one indicated in discussions between her lawyer and Mr. Combs' lawyer for the very first time, 5 years after the relationship ended, that she had been actually abused by Mr. Combs, again demanding $30 million. So first she wanted $30 million from the book, and he said, go to hell. Then she said, well, listen, he sexually abused me, and I'm about to file this lawsuit. So you can give me $30 million based on this lawsuit. And so that's supposed to be, according to them, when this, when all of these allegations of trafficking and all of that stuff came up. To be clear, the statute of limitation for non-sexual assault, battery, and other alleged offenses were subject to the typical statute of limitation for those torts. Accordingly, the only way, so basically it had been so many years, she didn't have any way to bring it but to do it under this Adult Sexual Survivors Act. Remember how everybody started hitting with these lawsuits? It was like L.A. Reid, We had Jimmy Iovine, we had Jamie Foxx, we had all these people that got hit with these lawsuits around this time. And I think before that, they may have been the statute that a couple of them we just weren't looking under these statutes like then. That's what they were doing it on, when people were like, why are they able to do it from years ago? This gave you a look back where if you can prove sexual assault, because the main lawsuits that were filed were those that were great while they were in prison. It was a lot of women that got pregnant and all type of stuff over there in New York. So this was their way to be able to grasp that. And the majority of these type of lawsuits were basically based on them. And then Cassie got her a lawyer, and they were able to, and other people have done this with celebrities. And so she's saying that because she really didn't have a cause of action, she basically used this adult survivor statute in order to get money out of him. Accordingly, the only way a plaintiff could avail herself of the ASA is by alleging this sexual assault. Thus, on November 16th of 2023, days before the ASA expired, Cassie filed a civil complaint alleging ex trafficking. The case settled quickly without any admission of wrongdoing. With the release of the civil complaint, law enforcement saw an opportunity to build a criminal case against Mr. Combs. Discovery shows that within days of the civil case settling, the investigation began. The government recycled her allegations, but the case requires her potential testimony, which will be refuted by years of written correspondence and other documentary evidence. So they're saying she gonna have to testify to all of this stuff she said, and we got documentary evidence. We got proof against Cassie. That's what they saying. What y'all saying? So Brandy said, this doesn't move me at all. We saw the video. So you're saying because you saw a 2-minute video that you can't believe. Just trying to make sure I understand what you're saying. Because you saw a 2-minute video of what happened where we don't have zero context except that he did what he did. And I hope she popped him upside his head when they got back in that room off camera. I hope it was a bat somewhere where she could have swung on him or something. Like she knew the cameras was out there. So she like, I ain't gonna hit him back out here, but I'm about to get my lick back. But nonetheless, I digress. You think that because of this 2-minute video, then it can't be plausible that this was just a jacked up toxic relationship and that she was extorting him for money. That's what you're saying. Based on the video alone? Is that what you're saying? I'm just wondering. So you said, so if it's bribery and extortion, then why settle the lawsuit when you had text message? Well, people settle lawsuits all the time, so I can't some for different reasons. Mainly because you're gonna pay your lawyer a few $1 million to represent you. So if I can settle, give you money so you can go away and we can get this out the media, then I'm gonna do that. And I'm not going to admit wrongdoing. So they put that in there. So the settlement was, and I'm pretty sure I said it before, the settlement agreement is going to say, this is not an admission of wrongdoing. And in fact, I emphatically deny that this happened. So in that document, I'm sure he straight up denied it. You know, you're not going to see too many settlements where like, I'm going to admit that I did it. I mean, sometimes people are trying to make that a criteria if they're winning, like winning. But for the most part, they just settle to get it over with. So there's various reasons, just like there's various reasons why some people plea. When you look at Thug, for those that's following the YSL trial, his attorney was like, I want to take this to the mat. Like, I want to finish this. I feel like we're winning. And they can't prove their case. And I don't believe the drugs, all the stuff he pled to, pretty much he's saying he had an explanation for it because he didn't live in that house. He lived in California and it was other people. But because I want to go home, I'm tired of being detained, I'm going to plea. So some people also plea. And you have people that try to take their pleas back later on and claim wrongful conviction based on a plea as well. They may say they were coerced. They may say somebody wrote it for them. they just wanted to go home, their mama was dying, whatever. People have different reasons. So I don't necessarily, just because you settle or you plead, necessarily figure you must have did something wrong. But I know a lot of people do look at it that way. Understandably, if you're not in this game like that. Well, if she made it up, that video must have been AI. That's not what nobody said that. No, nobody can negate that the video didn't happen. And eventually he had to admit that he can't say that wasn't him in the video. But what you're saying is that it can't be that it was toxic relationship just because you saw the 2-minute video. That's pretty much what you're saying. The video is her case. So what if he got a video of her hitting him? Then what you gonna say? Just hypothetically, if in their discovery they have videos of her, he laying sleep and she just go bust him upside the head with a iron, or she throw grits on him, then what you gonna say? They still on him? That's it. We'll see. I don't got enough information, but it's the settlement that opened the door for him to be in jail. Therefore, if he had proof of an alleged extortion, he should have fought back. Huh? I'm confused. You don't think he's fighting back right now? He can't stop them from the indictment. He couldn't stop the feds from indicting the government from indicting him. She filed the lawsuit. You have to look at it like this too. This opened the investigation, but they raided this man's house more than one. But the indictment is primarily, even though they said they may supersede it with more as they get more information, they investigated him for almost 7-8 months before they indicted him with search warrants, but they still only indicted him based on what Cassie said in her lawsuit for the most part. Because the blowing up of the car that you're mentioning, that was in her lawsuit. And Kid Cudi, and it was supposed to be that he didn't do it, but I guess he ordered somebody else to do it, is what the allegation is. And Kid Cudi said, yeah, my car was on fire and I did do a police report. So there were police reports, I guess, that's to it. So why would, if it's been like 9 months and the only thing you're talking about is just Cassie, they're saying they have information. That's all I'm saying. I don't know that. I ain't got a dog in the fight. I just try to get you guys to look at it from both angles. And how you guys are talking is exactly why he won a gag order, because he feel like his client is prejudiced because everybody already just believe he did it. And no matter what argument he come up with, because of that 2-minute video that nobody knows where it came from, because the government is saying they didn't have that information. They said it wasn't a part of their raid. It wasn't a part of the stuff that they got. So the video just mysteriously decides to come out randomly and goes to CNN, and all of this stuff happens. And so some of your comments are kind of confirming what he's saying, that he ain't gonna be able to get a fair trial because people just have it in their head. They don't care what he come up with. Everything gonna sound stupid and ridiculous because they saw that video. They like, no, whatever they said you did it, because I seen you kicking her in the head. Diddy definitely tapped that ass. She has a history of torturing females and was in an actual relationship with. This is not an extortion on Cassie's part, but if it is, and okay. Does she have witnesses? I don't know. Whoa, you say you think Puff will make it to court? I hope so, because I want to see. I want to see this evidence on display. If I could get up in that courtroom, I know it's going to be crowded because they go to settlement conference and all of that basic stuff that nobody goes to. A lot of times they used to do it on Zoom. They don't even really do that stuff in person, but they're doing his in person. The video is authentic. However, there's more to the story. Yeah. I don't believe no one made her stay. She could have went somewhere else. She wanted a spotlight and she got it. And I think that brings up, not to even sound, not to sound insensitive, but I think that does bring up a point that you do have some women, and I'm not saying this is Cassie's position, I'm just saying, just me generally in life knowing, you have some women that are willing to compromise their integrity and respect for themselves because they want the limelight or they want the money. So does that come into play? What are you willing to give up? Are you saying that Diddy is responsible for making her care enough about herself as well to leave him? So that's going to be another thing that's going to happen with the trial. And I'm sure it's going to be experts that come in to tell you the pathology behind someone staying in these type of relationships and the control, because there was a power dynamic. He was older than her. He owned he was older than her. He was in a position of authority because he was the one that could hold her future. But she wanted to marry him. Remember, part of why, if you listen to Roger Bond, who was, he said he was real close with Cassie until Cassie overheard a phone call, because Cassie really wanted Diddy to marry her. And Diddy was like, he was on the fence because he loved Cassie, but he loved Kim. So he was asking Roger, yo, who should I marry? And he said, listen, you got kids by Kim. Basically, he told Diddy, you need to marry Kim. If you're going to marry anybody, marry Kim. And apparently it was a butt dial or something, and Cassie heard it, like through the phone. So from that point on, Roger was saying that him and Cassie, like, they were cordial, but she told him, I heard your conversation. So she was trying to get Diddy to marry her. And the fact that he didn't probably was a blessing in disguise, because she seems like she loves her husband and, she loves her kids. She got a cute little family. But then I heard she also was getting major allowances from, somebody told me she was getting like $30,000 to $50,000 a week or every 2 week allowances allegedly when she was with Diddy. So she was living pretty good as well, allegedly. This is all speculation. I'm just looking at all this stuff on the internet like anybody else. I don't know any of these people. I don't know what reports or complaints that were released. I don't know what you're talking about. Are you saying there are some legal documents released addressed to why she stuck around? I don't know. Sometimes DV victims don't know how to make the first step to get out of a relationship. Yes. And then she had family, it sounded like, because I was watching a video and her brother was with her when they were discussing, she was with Diddy like they were together. She did an interview. It was probably 2017 or 18. So it might have been around the time they ended up breaking up. And her brother was with her at the studio. So she was around family. A lot of DV victims, they isolate you where they don't want you around the family. Like they become your family. So I thought it was interesting that her brother, and it sounded like some of her family was actually around her, because usually that's what I was thinking, was maybe she was isolated and then that's kind of who she thought that's all she had. But then you also get some people, was he doing things for her family? Like, was he buying them houses and cars and land? And that's why they, because I don't see how you can be around it and not know. And then from my understanding too, there was drugs involved on both ends. There was some rehab. From my understanding, there were different things, I guess, that she's had to do to try to come out of that. So it does sound like it was toxic, but she was a kid getting into that situation. At 19, even though you're an adult, you're a kid. So I can totally see where you got morphed into that, because somebody did, it was a video I saw and they were alleging it was the Kalani, from Dirty Money. She was saying how she was the party girl and she was the life of the party, and she would, like to have fun and do this and do that or whatever. So I don't know. We gonna see, but I'm sure it's gonna really come down to a lot of these experts that try to explain domestic violence and domestic violence situations, and because a lot of the questions that you all have are the same questions that people are gonna have as a juror. Like, Some people say, why did you stay? Why didn't you leave? Nobody told you to stay for 9 years or 10 years or however long you were there. Why was you taking this money then? Why you ain't walk away? Your mama knew about it. Your brother knew. It's going to be a bunch of questions. So they're probably going to have experts that explain why people stay, or even why after it happens, they still communicate with you and you're still cool with them, or you still try to have cordial relationships with them. It was somebody said she looked high as a kite on that recent interview. Somebody that was there with her all day, because a lot of people were saying that. If you look in, I think it was on the Shade Room, they said they were with her all day and she definitely was not high and she was not drinking. So even though she looked that way, I don't know her normalcy, so I can't say one way or another. Sometimes people are just nervous. Sometimes people are just, the questions were uncomfortable. I don't know. So I can't say yay or nay, but somebody was in the chat that said they were with her all day. I don't know if they were her assistant, and they said she had not drunk anything and that she was quite fine. The legal documents that caused her to pay within 20. Okay, that was the complaint, Gwen. That was just the complaint. It was an allegation. And that's what I'm saying. She didn't say, if she said why she stayed, or her attorney put why she stayed in there, that was just to make it make sense. And it's just an allegation. But that's the document that caused the investigation to happen in the first place. So that's all I'm saying. Okay, Gwen, I'm gonna need you to stop using these exclamation points, sweetie, because exclamation is strong, means you're having and everybody that knows me know I don't like all caps and I don't like exclamations because it sounds like you're yelling at me. So maybe you don't know that about me, but I read it just how you write it, because I am a writer, because I have to write briefs. And them exclamations, now I let you do it the first time, but now every single sentence you putting in freaking exclamation parts like you yelling at me. I'm not understanding why exclamation points is relevant to this conversation. We're just discussing and we're all trying to look at all sides like we do over here. So I'm gonna need you to relax. All right, Gwen? I'm gonna need you to relax, sugar. No worries. The settlement was in a civil case. The feds came knocking for criminal charges. That's the big difference. Yeah. It was just allegations, and of course you don't. And it was written for the feds. Like, it was written, it was so detailed, because when you write complaints, if you guys see how normal complaints with people that are not like celebrities, it's not going to go in the media, like our regular lawsuits, we ain't putting all that stuff in there. They putting pictures and hyperlinks and everything in these complaints. Usually you just say so-and-so was rear-ended by the defendant because he was driving negligent and wasn't paying attention. Count 1, non-economic damages. Like, you don't really try to put all that. These complaints are being read for the public, for the media to read them. That's how they're being drafted. 50-page complaints that read like a story is something you don't need in a complaint. So therefore, you're just doing it because you want us to see the story behind it, because you want the salaciousness and the clickbait, because sometimes some of that stuff forces people to settle because you want to get it out the media. You see how fast he went and tried to settle this case with Cassie. And Pat said, Gwen, just passionate. Pat said, who you talking to? I was trying to do better. You know what I'm saying? I used to immediately say something, but now I just like, see, okay, maybe that was just one comment. And they was, I like the passion for it. I like the zealous advocacy that you're having for Cassie. I like that. But then I was like, after the second one, I'm like, sugar, sis. Like, I'm gonna need you to, we can do a period, all right? We don't have to do exclamations, Gwen. We love you, and we appreciate your zealous advocacy, okay? We really, really do. We know what side you're on, but we just like, come on, just bring it down a little bit. Thank you so much. Just Discerning A said, I'm a new subscriber. Thank you for all you do. Thank you so much for the super chat, and thank you so much for subscribing to the channel and giving us a shout over here. I appreciate that. Ray Bishop said traditional complaints are boring. These are tea. That is the truth. Traditional complaints are boring because that's what I write them. Most of the time, you have your secretaries or your paralegals write them. Like you're just trying to get up in the lawsuit, get your money, and that's that. But in this is a high profile case. So you got to give it where they're like at 5 o'clock in the morning, the sun was just rising. And you can see the glimmer through the window, and the glimmer struck the face of the defendant. And she was blinded. And as soon as she was blinded, the plaintiff came in to pick them up off the floor. This is how this stuff is like being written like creative writings. I'm like, these complaints would make good scripts for like movies or something. That's how a lot of these complaints are being written. You know what? 504 still calling me Pat. 504, stop with them caps, okay? And them exclamation points. Cut it out. He said you up mighty late, Pammy. Pam, I'm here for it. I am. I just got home from Atlanta, so that's why. I think Dev done went to bed. He ain't been in this chat in about an hour. It's like, oh yeah, she not gonna be on for 30 minutes. I see she up here having fun. You said, I hope Diddy does get a bond so he can show everyone how much of a devil he really is. Dang, Gwen! Gwen! Gwen, okay. All right, Gwen. Okay, sis. She is not a Diddy fan, okay? Jeez. Okay, so then you said, I don't understand why is the evidence for the alleged extortion not used for the civil case. It would have helped him. I think that accusation was serious. What do you mean, why wasn't it used for the civil case? So you're saying instead of because what Diddy thought he was going to do was hurry up, pay the money, and move on. He did not know this was going to be an avalanche of civil cases, and he could not foresee this was going to open up a criminal case. So he thought he was making this go away. That's why he paid. If he would have known that this issue was not going away, you think he would have gave her all that money? Nope. He wouldn't have gave her nothing. But because that was the point, he was trying to get it to go away. But like Ray said, perhaps you should have paid that $30 million before. But you got to look at it like this, because that's what I said. I know they sent a demand letter, and I know they probably attached a complaint. I didn't know anything about the book that she said, give me this $30 million. Instead of that, I won't write the book. I'm going to go ahead and I'll let you have the exclusive right to the book. And then you just give me the 30 million and shoot. The attorney was like, shoot, I get a third of that too. Let me go ahead and go through this deal with him and try to get this book, get the exclusive rights and get him to buy this book. So perhaps when he looked at that complaint that was attached to the demand, if they sent the complaint, perhaps he was like, oh, this some BS. Like, girl, stop. You know this ain't what our relationship was. Why are you even saying any of this stuff? You can't even prove half this stuff. Maybe that's what he told his attorney. So his attorney was like, I wouldn't pay that. Me, I'd have been like, how much money you got in the bank? What you got available, Diddy? Like, we got this is not good. And she put names in there, like Kid Cudi and all of that. So apparently there was some of the stuff, there may have been some validity to allegedly, because Kid Cudi came out and corroborated it. Then you had some of her friends come out and say, yeah, Diddy was controlling and he did this and he did that. So I think that he just didn't think it was going to go as big as it did. I just think he didn't think that. And he miscalculated. And a lot of people miscalculate. And he was one of them because he should have settled it. But because of that, so you're basically saying that you believe that if it was an extortion, he should have responded and said she's trying to extort him. I mean, that wouldn't really help the situation. That would have kept it in litigation. Meaning now I got to try to come with evidence to respond. You can't get it dismissed based off of that because she made allegations of sexual assault. So, and then it was not, the statute of limitation was somewhat revived for the last year. so she can file this. That is a question of fact for a jury, whether she was abused like she said she was, whether she suffered intentional infliction of emotional distress. Will a jury feel like that is outrageous behavior for somebody to allegedly drug you up, as she's saying, and make you have text X with all these random people, and you go pick people and you go watch, and you don't want to do it, and you having 5-6 people coming to do this to you throughout the day, and all of this stuff that she was alleging? Thank you so much. It's so kind of you. Peanut said it. I appreciate the super chat. It's very nice and very, very generous. Thank you so much. So it's a lot to it. It sounds simple to just say, well, why you ain't just respond to it? But now you got to go through all of litigation. And we would have been pulling up every document. Every time they filed something, we would have been over here talking about it. So he thought he was going to get rid of the case, and he miscalculated, because what it did was cause an avalanche. So people started coming out, me too. Me too. Me too. Me too. You know, and then it was just nonstop, and there was nothing he can do about it. And then with those type of allegations, how can the feds really turn their eye to that? Those allegations that she made were strong. And so because you're saying, like, if true, that's like horrible. How the feds just gonna turn their head and say, I ain't see it. I ain't see this complaint. And they were able to find police reports of different things happening, and like different things people were alleging against Diddy or some of his associates, and nothing happening. So they were almost forced to do something about it. Diddy wasn't trying to be in court like Johnny Depp and his ex. That part. Because what they would have, man, please. The only thing is it's in federal court, so that can't be streamed. Federal court does not stream or record or allow recording. But baby, if this was filed in state court and you can actually stream it, do you know how you thought YSL was banging with the viewers? You know what? 504, go to your room. It's late. It's 1:30 in the morning on the East Coast. He said, oh, okay. So instead of fighting, he settled the demand because he miscalculated. Got it. I'm a class learner. So he would have had a trial with discovery. Got it. Now, thank you. Yeah, he would have been in court probably at least a year and a half before he got a court date. When you're in federal court, you kind of set and let them know how much discovery you need. They had a 10-year relationship. So they probably would have asked for about 9 months of discovery to be able to do depositions, to try to subpoena documents and all of that stuff. That's just your discovery period. This would have been out here, and baby, everything they filed, we would have been over here like a new document was filed today. We've been over here talking about it. Even 50 Cent said he sent him pictures that was not appropriate for a girl he claimed to like. Oh, wow. Dang. Community. Hey, community advocate. Good to see you. Yeah, we burning the midnight oil. We are. Thank you so much for coming over here. Kelly said, you may be right, but the nature of that video we all saw was extremely damaging. It was, but it's not a. So what they're arguing to, because we done went all to the left. We ain't finished the document. But what they are arguing is basically that the government is trying to equate the freak off to make that video seem like it was coercion to make her stay or something, so that she has to participate, which will make it look like trafficking. Like with trafficking, you have to have coercion and all of that and threats. So they're connecting those two. But what he's saying is, no, this was a couple that had a DV toxic type relationship, but it had nothing to do with a freak off. But the way she said it in her complaint was like she mentioned this incident. So that's why I'm almost thinking she may have had a copy of it. I don't know who the heck released it. It's all speculation. But I think it's interesting that she decided to put that incident in the complaint of him kicking her and all of that. And then she coupled that with, she said it happened after a freak off. So what the government did was connected to, like it was some type of coercion or threats to make her stay to participate. His argument is basically that's not true. She had hit him with I've heard two different stories. She had just struck him and then left with his clothes. That's why he was out with the towel. So that I don't know how true any of it is, but that's what I had heard. And so that's supposed to be, he has a whole different version of what happened. He has a different context, and he said it had nothing to do with a freak off. The government is putting it together to show that video as evidence of force and coercion to stay in a freak off, as opposed to just a domestic violence relationship, if that makes sense. So that's what they're arguing against. Thank you so much, Sister Craft. You said, hey, Pam, just want to say thanks for all your awesome videos. I've learned so much from you. Keep up the great work. We need more strong women, especially now. Thank you so much for the kind words, and thank you for your generosity. I appreciate that so very much. No, you cannot unsee the video. I agree with that, Gwen. I agree with that. Ray said, even if Cassie's motive was solely a come up, there's at least some truth to her claims, or they'd have tossed this out already. They like the feds? You think they would have tossed it out, child? You said you think the government would have tossed it out, right? Ooh, Gwen said, Gwen, who can't stand Diddy, said Diddy should have been more creative with his lies. She said, the lies. She wants Diddy to be quiet, and she can't take the lies. She said, we do not victim shame over here. That's what she said. I hear you. I really do. I really hear you, and I can appreciate your passion. Okay, let's finish with this document, because child, it's like 2 a.m. here, and I'm still over here and ain't got through nothing. The alleged second victim. So apparently they got evidence on the alleged second victim. During the initial bail hearing, the government alluded to a potential second victim, arguing that Mr. Combs' contacts with his purported victim were evidence of obstruction. September 18th. However, blank, blank, blank. Y'all won't know because it's redacted. Despite the government's claim, redaction, that the woman is an ex-trafficking victim, the defense has learned that the government has not even spoken to her, nor was the target of any obstructive conduct by Mr. Combs. So apparently in the bail hearing, they mentioned a victim too, and they're saying, despite the government's claim, they haven't even talked to the lady. So how are you saying she was trafficked and you haven't even talked to her? That's what they're saying. The government clearly misled the court and concealed the true facts during the initial bail hearing. For example, the government knew redaction. The government also knew redaction, but the conduct was nothing of the sort, which the government clearly knew. Indeed, the discovery confirms some more information that they're not going to let us see over here in the public. I feel like they shouldn't have no redactions. We are invested in this case, and we need to know everything that is happening. That's what I think. But anyways, let's go. The government's other obstruction and witness tampering allegations were false. The discovery also undermines the government's argument that Mr. Combs attempted to tamper with other individuals, including grand jury witnesses. During the previous bail hearing, the government outlined what it billed as obstructive communication with grand jury witnesses in June and July 2024. It further characterizes Mr. Combs' September 2024 communication with another person as witness tampering. Judge Carter considered this the government's most persuasive evidence, posing the question to the defense, quote, if he's aware of this April 1st, 2024, then again, why is he contacting witnesses in June and July 2024? And what will be the purpose of Mr. Combs continuing to speak to that witness after September 11th? But the recent discovery now corroborates the defense's arguments at the initial bail hearing. At the hearing, Mr. Combs' counsel explained that his contacts with these people were not in any way obstructed. One grand jury witness contacted him, not the other way around. So he's saying they contacted him. The September 2024 communication were with an individual represented by counsel who wanted to make a public statement. So that must have been Kalani. And to the extent individuals were contacted, defense counsel explained that to conduct a responsible defense investigation, it must, of course, continue to interview witnesses. In opposing these arguments, the government misled the court and concealed the actual content of the communication. The truth, however, is that a grand jury witness, the one with whom Mr. Combs had spoken in several years, you guessed it, we won't get to know because they redacted it. These statements, which the government conveniently withheld from the court, in no way evidence obstruction. The same is true of the individual whom Mr. Combs contacted in September 2024. And you guessed it, intellects, it's redacted. We will never know. But during its proffer to the court, the government concealed these facts, which completely undermines its claim that the timing of the contacts with the person in September 2024 suggests obstruction. Mr. Combs is entitled to have his counsel conduct a thorough defense investigation. Indeed, his constitutional right to the effective assistance of counsel demands it. At times, counsel might also need Mr. Combs' assistance and involvement to conduct a proper investigation. Of course, Mr. Combs has a constitutional right to participate in his defense, and if witnesses are contacted to support his defense, that alone does not amount to obstruction or evidence any risk of obstruction or danger. Then they have another alleged new evidence where they say the testimony of unknown undermines the government's case. Defense counsel noted at the initial hearings that based on defense interviews and investigation, several individuals associated with a male companion agency have stated to the prosecutors that they are paid for their time, not for X. So they said they paid for their time. They're not paid to get it in. And at the time of this submission, no Brady disclosure on this point has been made. So basically, they did their own investigation and talked to the person, and they let them know, hey, we told them that y'all get paid for the time, not for X. Like, we ain't got nothing to do with that. If they choose to have X, that's on them. However, they're saying the government hasn't turned over any interviews with this male person that owns this companion agency, is what they call it. This is not a surprise, as the companion agency is not some secretive underground operation. It has been operating in the open for over a decade with a website of over 10,000 followers on X, and its operations have been featured in well-known magazines. Its CEO actively courts media attention, starred on a Showtime series about male companions, and has been repeatedly interviewed on national talk shows and the national news. Who they talking about, y'all? According to the CEO, the company's services have exploded in popularity because of all this publicity. In other words, the government's allegations are incredibly weak and contradicted by the testimony of its own witnesses and the discovery received to date. Y'all hear this? They're saying the government is not being honest. Companions, that's what they said, 504, they companion agency. So you can call and say, if you think you're lonely now, wait until tonight, girl. Then you talk about you're lonely. Let me see. I'm so lonely. And you can just call, look up on X. Do you have any available person 5'2", 120 pounds? I just want a companion. That's it. Nothing more. I'm willing to pay for the companionship. That's it. And that's what they say they did. They didn't pay for nothing. They are not an illegal. They are a tax-paying company, and they do not engage in illegal activity. That's what they're saying. 504 said, I get so lonely. Can't let just anybody. Well, I don't know. They let anybody, it sound like, if you available. They're like, come on over to my place. Okay. Mel Lee said Trump about to pardon that man. Child, everybody's saying that. Everybody is saying that. So let's see if it happens. Let's see if it happens. Dang, Gwen said double the amount originally offered. Gwen got her foot on your neck, bro. She don't care who lied, who omitted information, who was holding back Brady material. Your bond need to be 100 million. And you still need to be denied. Oh gosh. Nah, we might have to give Gwen a hug. We might have to support Gwen over here. Oh, Lord have mercy. All right. So then they go on to say, Mr. Combs' character. Oh, this should be real good. Gwen, hold your horses, Gwen. Gwen, hold your horses. They're getting into his character. You know, in the words of Ernest Williams, it's about my character. People know I ain't worried about that. Because people know my character. So Diddy is about to talk about his character right now. So y'all ready for this? You might need to get some snacks. Let me stretch. His character. See, they sending you virtual hugs, Gwen. You seemed a little uptight. We're trying to make sure you're okay. We're a family over here. We a legal family. Leave Gwen alone. She an activist. Go on and fight, girl. Gwen gonna be out there with a sign. No justice. Ain't no justice. Ain't gonna be no damn peace. That's gonna be Gwen out there. I'm gonna see Gwen getting tased. She's gonna be outside of the court getting tased. Right, that part. 504 said, I'm just messing with you, my girl. I don't want no smoke. All right, let's hear about his character. The Bail Reform Act requires courts to assess a person's character, physical and mental condition, family ties, employment, financial resources, length of residence in the community ties, past conduct, history relating to drug and alcohol abuse, criminal history, and record concerning appearance at court proceedings. So let's get into his character. We're going to read this like he getting the key to the city or something, because I'm sure that's how this reads. Mr. Combs has never run from a problem. He has had more than his share of adversity as he does now, and he has responded with every such challenge with integrity. Sean Combs was born on November 4th, 1969. Happy belated birthday. At Women's Hospital in Harlem, New York. His mother, Janice Combs, was a teacher's assistant. So she was like an aide. She was like a lunch aide. His father, Melvin Combs, died when Sean was 3 years old. His mother and others told him that his father died in a car accident. It wasn't until years later, when Sean was a student at Howard University, that he researched microfiche and learned his father was unalived. You almost got me there. I was going to say the word. Determined not to let her only son follow in her deceased husband's footsteps, Janice was perhaps extra protective of Sean. She raised him with a strong belief in God. You knew God was coming in here, right? religion, faith, and redemption. At the age of 10, he became an altar boy at the parish of St. Charles Borromeo at 282 West 151st Street in Harlem. He also spent his Sundays at the Shiloh Baptist Church, where Adam Clayton Power Jr. 226. Oh, I thought that was the pastor. My fault. I was getting too into my reading of the bio. It's at 2226 Adam Clayton Powell Jr. Boulevard in Harlem. When Sean was, because I was actually gonna look him up, like, who is this bishop? When Sean was about 12, he and his mother moved to Mount Vernon, a small city in Westchester County bordering the Bronx. Sean attended and graduated from Mount St. Michael Academy, an all-boys Catholic high school where he played on the football team. His ties to the community run deep. You guys see this? We're talking about his character. Let's go on. Oh, that's your grandmother's church. Do she know Sean Combs' family? What bench does your grandma sit on? What bench did the Combs family sit on? You said the boys' school messed them up. Ooh, Queen Keish. You sitting up there. You said you were about to analyze this thing. Okay. Let's get into his career and work history. Now, this is his resume. This is his CV. While a student at Howard University in Washington, D.C., Mr. Combs began working for free at Uptown Records, which was created in '86 by Andre Harrell. We heard a lot about Andre Harrell, too. To be the first major hip-hop music label in the world. Combs bunched his classes at Howard on Tuesdays through Thursday and took the train to New York to work with and learn from Harrell the rest of the time. He quickly distinguished himself by his hard, tireless work. Harrell rewarded Combs' hard work by making him an executive at the label. However, with hard work comes drive and ambition, and Harrell fired Combs in '93. He said, "You're fired." Instead of seeing this as a setback, Combs saw it as an opportunity. He created Bad Boy Record that same year. The 24-year-old Combs had a vision for a new type of business, one headed by a young Black executive that emphasized Black excellence and achievement. It would reflect a certain style, sound, and sensibility that was modern, hip, and urban. Before long, many of the most talented young artists signed with Bad Boys. In June of 1997, Combs wrote and sang his first hit song, "I'll Be Missing You," with Faith Evans, which is a tribute to his friend Christopher Wallace, better known as the famous and talented Notorious B.I.G., who was unalived in LA 3 months earlier. Do y'all know that Miss Wallace, I think it was Gene Deal, had a video where he called Miss Wallace, who said, "It's cool if you want to go ahead and drag Buffy. That's what's up. Like, you can go." She ain't said in those words. Those are my words. But she basically was like, they asked, "How do you feel about him talking about Puffy?" That's cool. You go ahead and do that. Every step I take, every move you make. And then that beat was that's for y'all that don't know what the song is. Okay, let's move on. So then what had happened was in February 1998, Combs' debut album, No Way Out, won a Grammy Award for the Best Rap Album. This is the bio. Said, "Wow, you still on?" I am. And I'm not even sleepy. Okay. Let's move on. So now we're going to talk. Later that year, Combs started the clothing business Sean John, which went on to win Council of Fashion Designers of America award. Combs was the first Black man awarded the CFDA Men's Designer of the Year award in 2004. In 2002, Combs produced the MTV reality show Making the Band, 5 years later, in '07, Combs became the brand ambassador and equal share venture partner with the British multinational beverage company how do you say it? Diageo, I think, for the French beverage producer Ciroc. And in 2013, Combs co-founded a television network called Revolt, which carried music videos and programs related to social justice issues as well as music. However, in the wake of the November 2023 lawsuit, he took a leave of absence from many of these ventures. You stepped down, honey. They told you, get thee behind us. That's what they told you, and you stepped down. But I can appreciate, how you're and since he brought up making the band, and we're just on, right now in the middle of the night, there was another lawsuit that was filed a week or two ago. And this is somebody who is alleging this. Okay, this is over there in state court, but let's get to the facts because this is by Busby and they kind of say the same stuff in the beginning. So these are the facts. This is about making the band. Making the Band was a reality television series that aired on various networks, including MTV from 2000 to 2009. The show, created by Lou Pearlman and later produced by Combs, followed the formation of musical groups through a competitive audition process. Aspiring singers and performers competed for a spot in a new music group with the ultimate goal of signing a record deal and achieving fame. The show combined elements of traditional talent competitions with the drama of reality TV as participants lived together and faced elimination based on their progress. Throughout the series, contestants underwent rigorous challenges, including vocal and dance training, live performance, and personal development tasks, often under the intense scrutiny of industry professionals like Combs. In or around 2008, Plaintiff, then 17-year-old, participated in a 3-day audition in Making the Band, having seen the opportunity online and through newspaper advertisements. During the audition process, Plaintiff advanced to a stage where contestants met individually in private rooms with Combs and his bodyguard. On the first day of the audition, during a one-on-one interview, Combs asked Plaintiff hypothetically questions about handling situations involving actual pressure. As Combs described these scenarios, he began to actually assault the plaintiff by touching plaintiff both over and under his clothing, including groping and fondling his genitalia and instructing plaintiff to undress. While he groped plaintiff, Combs engaged in actually explicit behavior, including pleasuring himself. Throughout this encounter, Combs emphasized his power to control plaintiff's future in the music industry, stating that he had the ability to make or break the plaintiff's career. On the second day, plaintiff went through a longer interview process. During this interview, Combs again instructed plaintiff to undress, explaining that plaintiff needed to demonstrate the ability to embody a ex-idol persona, which was purportedly required for the band's image. This encounter eventually escalated into Combs forcing the plaintiff to perform oral on him and Combs sodomizing the plaintiff. Combs continued to reiterate his power to control plaintiff's future in the music industry. On the third day, Combs introduced his bodyguard T into the actual advances. This is day 3, honey. I would have been gone after day 1. But this is on the third day. Combs introduced bodyguard T into the advances. Combs framed this as a test of plaintiff's willingness to do anything necessary to succeed in the industry. T requested oral from plaintiff, and while plaintiff complied due to force, Combs actually assaulted plaintiff again, simultaneously groping and fondling both plaintiff and the bodyguard. Plaintiff's facial expressions during this ordeal showed his discomfort and hesitation, prompting Combs to express dissatisfaction. Combs stated that plaintiff's demeanor suggested an intention to report the incident, and as a result, Combs said he would be keeping an eye on plaintiff. Ultimately, this led to plaintiff's elimination from the competition, as Combs claimed the plaintiff was untrustworthy due to his reservations about performing oral X on the bodyguard. As a result of these assaults during the audition process and plaintiff's reaction to them, plaintiff was excluded from further opportunities in the competition and was unable to return to the music industry for 7 years. So I have so many questions. I get that this young person was 17, but I'm wondering where the parents were when all this was occurring. And after the first day, when you seen this was a bunch of shenanigans allegedly, why would you come the second and third day? And then you didn't leave because you left because you were something was happening bad to you. You left because you got eliminated. So a lot of these lawsuits are going to be he said, she said, because I don't know who is going to corroborate this. And of course, he's going to deny it and say it's all not true. So we need some of these people that were making the ban. If you guys can approach the bench and let us know, did you hear any grumblings, or whispers of them actually trying to see if you would engage in what you are willing to do in order to be in the band? Were you guys a part of any of this? We want to know, because there were a couple of making the, a couple of groups that were made because of making the band. That's what we want to know. You said which bodyguard? They said their name was T. We haven't heard anyone named T. We heard of Gene Deal. So that would be T. We also heard of it was another one that was a company that Thalia Graves, who is being represented by Gloria Allred, she named somebody in her lawsuit, and I don't think his name was T either. And then you have Roger Bonds, his name isn't T. So I don't know who the person is. And I don't know, saying the name T, I don't know how you would even find who that person could be. And they obviously don't know him because they sued him. And this is the judge is allowing this person to remain anonymous as John Doe. So we won't know who the person is. So of course they sued Sean Combs and all of his quadrillion entities, and then individual Does 1 through 10. So we don't know who that person is that they're alleging is the bodyguard in this case. 504 said, I'm glad I never wanted to rapper sing. I used to want to be on Nickelodeon, and I even tried out for that show Double Dare when I was a kid. And I remember, like, it was these twins that went to our church, Katina and Katrina. So me and Katrina were partners, and I have a brother that's older than me, like 18 months. He was partners with her twin Katina, and we tried out for Double Dare. You know how you go through the slime? I thought Double Dare was the joint. So we auditioned. I remember I got eliminated like the first or second round, and I was all crying and I was all sad. And my brother and Katina, they made it through. Like they made it through other rounds, but I was all in the car like, Mommy, that's not fair. Why did they make it and I didn't make it? I was smiling. I was like, I could make it. I was going through the obstacle courses. I was looking like, why would they do this to me? It's not fair. I was over there crying like a little punk, man. I was so mad they eliminated me. Then my brother and them, they made it a little bit further, but then eventually they got eliminated too. And I was really low-key happy. You know what I'm saying? I was like, oh, y'all ain't make it. But inside I was like, yes. And then now that I look at like the Nickelodeon stuff, all of this shenanigans allegedly was happening Nickelodeon to some of these kids. So, sometimes God protects you and you don't even know that you need to be protected. So we give God glory. God had a bigger plan. Wasn't Double Dare the joint, Kelly? Man, I just knew I was gonna get me a new computer, give me a new little Game Boy. They had little headphones and stuff, all them prizes you used to get. I was so disappointed. I might need to talk to my therapist about that. See, this is bubbling up because I didn't even, I haven't talked about this in years. See, this is therapy tonight. So anyway, I just brought that up just because they brought up making the band. So I figured I'll just add that little lawsuit part in there so that I ain't got to do it in a separate video since y'all on here. So anyway, let's move The brief review of Combs' work history shows that Combs responds to adversity by facing challenges directly. So basically, all this firing and suing is because he faces stuff directly and working even harder to overcome them. He does not run from challenges, nor does he cheat or break rules in addressing them. Instead, he takes them head on, and he has already done with the challenge, and as he will continue to do. Mr. Combs' contributions to the community. He's also a philanthropist. You know that was coming. You know the philanthropy was coming. So let's talk about his work. Mr. Combs is also incredibly philanthropic and cares about the community here in New York and elsewhere. Since founding Bad Boy Entertainment, Mr. Combs has actively supported and donated millions to after school programs and organizations like the Boys and Girls Club of America. He has also supported organizations including the National Foundation for Teaching Entrepreneurship, creating opportunities for young entrepreneurs. A cornerstone of his philanthropy is education, and he fulfilled a lifelong dream when he, with the partner, opened Capital Preparatory Harlem Capital Charter School in 2016 to provide high quality education to inner city youth in New York City. The success of this initiative led to the launch of Capital Preparatory Bronx Charter School in 2020, with Combs donating $1 million to support its development. Mr. Combs has also been proactive in health and disaster relief efforts, having raised over $2 million for New York City public schools and hosting a virtual dance-a-thon that raised more than $4 million to provide personal protective equipment to healthcare workers on the front line of the COVID-19 pandemic. Mr. Combs' philanthropic work has earned him numerous accolades throughout his career, including the Triumph Award from the National Action Network in 2016, the Superhero Award from Room to Read in 2017, the Child of America Award from the Carver Foundation in 2018 and 2023, the Icon Award from Apollo. Now let's talk about his family. Guys, ready to talk about his family? If you guys could hit that like button, we'll get into his family. Thank you guys for hanging with me this long. My goodness. See, some of you guys can't sleep, huh? Some of you guys can't sleep. You guys are looking for something to do, huh? At 2 in the morning. Let's go. Because the government argued that Mr. Combs is a flight risk and danger, we further address in brief fashion his history of long-term relationship and family ties. Although Combs never married, I have a sneaking suspicion that he probably will end up getting married. Let's see if that happens. Let's see if my suspicion turns out right. He has had multiple significant long-term relationships that are relevant here. He fathered his first child, Justin, who is now 30 years old, with Misa Hilton. He was in a long-term relationship next with Kim Porter, who he called the love of his life after her tragic passing from lobar pneumonia in November 2018. Please don't bring up Kim, because baby, now I'm gonna get all the conspiracy theorists dig up her body, do an autopsy. Her body needs to be exhumed. With Kim Porter, he shares Quincy, who he adopted. They said he adopted him. Wasn't that something where they said he really didn't adopt him? Or maybe he didn't do it in the legal sense? Because people were asking me about it, and I thought L.B. Shore said it wasn't true. He said who he adopted. Christian and twin daughters. He fathered his 18-year-old daughter, Chance Combs, with his longtime friend, Sarah Chapman. Chance is now enrolled at Tisch School of Performing Arts in New York University. Finally, he has a 2-year-old daughter, Love. What you know about Love? You said not legally adopted. Okay, Gwen said he did not adopt Quincy. Okay, Gwen, I put the exclamation points because I know you wanted to be emotional when you said that. So I appreciate you abiding by the rules of the intellectual platform and you didn't put them exclamations. But when I feel that there is passion, I will read your comment in a way of which I will relay the emotions behind your comment. And I know you want to say he did not adopt Quincy. I felt that in that comment. You see how this works? I felt that. I felt that. I know, girl, you ain't have to tell me. I already know. I'm feel okay, I got you. You said, did they skip over J-Lo? J-Lo ain't had no kids by him. They talking about the baby mamas. This is a very cute way of saying he has a bunch of baby mamas, basically. You gotta label it like long-term relationships. You know what I'm saying? So, like, when you have kids out of wedlock, you gotta voice things where it's not looking like a thottish type relationship. So, like, for instance, I have an older son. His father is deceased now. God rest his soul. He died like when we were young too, as well. But when I had my son, right, we never were married. So because of that, I'm telling all my business. But because of that, when we did the obituary, we had to put with the union with Pam, because they wanted to put me in there. We had so and so. You know, you gotta find a way where you ain't looking like the baby mama thought. You know what I'm saying? I was like, I thought it was pretty creative, right? How we did it with the union of Pam. God helped. God created their son, such. Sometimes you got a word play. That's all I'm saying. I'm just saying how I relate. I ain't exempt. You know what I'm saying? I ain't exempt. All right, let's move on. Cause how would that look? They be like, they put in there he had a son, and then put he leaves behind his baby mama. like how's that gonna sound? He leaves behind his baby mama. Kelly said that was a very Christian way to say it. Listen. So he fornicated with her. He gave his life to Christ at the age of 10. At the age of 10, he gave his life to Christ. But at the age of 23, he had a baby with someone that was not his wife. Like, how does that work? You know, we had to structure that thing so we could, still relate that he was saved, sanctified, and filled with the Holy Ghost. He just had a little slip up. You know what I'm saying? We had to like that thing. You said not sure baby daddy would be in my obituary. I'm just saying. That's all. Okay. Let's go on with the relationships because Deb is telling me to get off of here in so many ways. Mr. Combs also supports his 83-year-old mother who recently underwent brain surgery. I never heard of his mommy. Oh, yes, I have. I did see he did an 80th birthday party for her, who recently underwent brain surgery and was in the hospital as recently as this summer with heart issues. Although Mr. Combs is not his mother's only caregiver, he assists with his medical care. So he ain't his caregiver, but basically he pays for it, is what it sounds like. He makes sure she has good care. That blind lady said, just like the priest in my elementary school, I always wanted to eat lunch with Father Jack with some other kids. I'm glad I didn't later find out he was a weirdo. Yep, sometimes you get protected from things you don't even know you need protection for. 504, don't entertain this, okay? This up her alley. That was up her alley. So Mama Combs removed the wig. The gold experience. Oh, gosh, I'm not doing this with y'all. Sean Combs' 7 children and his mother love and support him and need his love and support. The mother of 4 of his children, Quincy, Christian, and his minor twin daughters, Kim Porter, passed away, and his children are now left with an incarcerated father. His minor child, now 2 years old, has not been able to see her father since he was incarcerated and misses him dearly. So that is the family reason why he should get out, okay? Oh, you said the feds is threatening to lock up the mama. Oh my goodness. That's DST 1095 said Diddy does take great care of Miss Janice Combs. See, people was trying to talk about their relationship and talking about the weirdness. I didn't know she was sick though. And I didn't know that. So y'all pray for Miss Janice on tonight. So it says he cannot adequately prepare for trial. At the October 10th, 2024 status conference, the government described an unprecedented volume of electronic discovery. This includes terabytes and terabytes of data extracted from at least 96 electronic devices seized at Mr. Combs' residence in Miami, Los Angeles, and elsewhere. On October 10th, 2024, the size of the data collected from Miami alone is extraordinary and totals over 90 terabytes. The data extracted from other devices includes yet more terabytes. Even a single terabyte of data is roughly equivalent to the information contained in the books on 12 floors of a typical academic library. Oh, that's crazy. The data here is so large that the government representative, it would need to engage in further dialogue with the defense as to how exactly this data could be transferred to the defense team. Those discussions continue, but that's not all. The government further described voluminous subpoena returns and Brady disclosures, and a particularly complicated privilege review process whereby the filter team will share initial batches of possibly privileged material with the defense for its own review. The government maintains that its investigation is very much continuing. Okay, whatever. Let me see. Let me go down here. The defense's recent attempts to confer with the government regarding Mr. Combs' use of a laptop further confirms the current conditions are not tenable. There is no way Mr. Combs can review all of this discovery during visits by his attorneys. He needs a laptop so that he can work on his case as often as possible on his own time. However, even though he has been in custody since February 16th, February. It's time for me to go to bed. September 16, 2024, he still does not have a laptop. Defense counsel has been working with prosecutors since Mr. Combs' arrest to supply him with a laptop that complies with MDC's security requirements. After numerous delays occasioned in part by the government's misunderstanding of the MDC's rules, counsel provided a compliant laptop to the government on October 8, 2024, nearly a month ago. Nevertheless, as of today, Mr. Combs has still not received or been able to use any such laptop, meaning he cannot review certain files while at MDC. This includes discovery that critical to his defense and trial preparation. The government has numerous case agents and endless resources at its disposal to conduct its review. So basically, he's not able to review his stuff. So let's go on to the conditions. And we heard about how jacked up those conditions were. But they say the current conditions at MDC further impair Mr. Combs' ability to prepare his defense. To start, the frequent lockdowns at MDC persist. As many judges in the Southern and Eastern District have observed, inmates at the MDC spend an inordinate amount of time on lockdown. These were the same arguments that Bishop Whitehead gave when he was trying to get out. Just last week, the long-troubled facility was the subject of a multi-agency law enforcement sweep and yet another corresponding lockdown. During that sweep and lockdown, Mr. Combs was removed from his unit so officers could search its contents. He was not entitled to be present for the search. Officers ruffled through his personal notes and left them scattered, out of order and disorganized. These notes included his work product and notes reflecting communications with defense counsel. The officers also seized Mr. Combs' pens, leaving him unable to take further notes while reviewing discovery or during counseled calls. As a result of this lockdown, defense counsel was delayed and meeting with Mr. Combs, losing time for trial preparation. So now he doesn't have anything to write with, guys. What? You heard his mama was really his aunt. Where you hear that at, Miss Lorraine? Did you hear that 1 terabyte? So the Gold Experience said, can't the lawyer bring and mail him the documents to review? Did you not hear that 1 terabyte is like one whole floor of a library? How you gonna mail that? First of all, you gonna spend $1 million printing it out. And secondly, a lot of that stuff on those drives probably aren't even relevant to this case at all. That means everything that he's recorded. And a lot of those videotapes, because he has 24-hour surveillance going around his house, and he's been doing that for decades. So I'm sure that they have a whole lot of surveillance and all type of stuff. What? Aunt Natty said, yep, word on the curb is his biological. Who is his mama? What you saying? You said give him some crayons. Isn't the way they make lipstick and they dye hair and stuff while they're detained? Maybe he can get like the Kool-Aid or something. That's what they dye their hair with. Get you some Kool-Aid and get a stick and start writing stuff. Or etch it in the walls. I don't know. That's kind of jacked up. They took his pens. That's bold. What? He made a gross video with his mom where he says his mom is a good time and likes her palms flat. Oh, Jesus, help me. Today on a video, one of the ladies that was in the freak off. Oh, okay. Wow, wow, wow. Okay, we're almost finished, guys. Release is required by the Constitution. Now they just giving the catch-all. Under the Fifth and Sixth Amendment, Mr. Combs is entitled to meaningfully participate in his defense and collaborate with counsel. The traditional right to freedom before conviction facilitates these rights by permitting the unhampered preparation of a defense. And they got a bunch of law and statutes. Although the Supreme Court has rejected facial challenges to the Act's procedures, it has not determined whether or not they might be insufficient in some particular circumstances, such as those outlined here. Keeping Mr. Combs detained under the extraordinary circumstances here would leave him unconstitutionally handicapped and consulting counsel, searching for evidence and witnesses, and preparing his defense. Indeed, it is well documented that pretrial custody status is associated with the ultimate outcomes of cases, with released defendants consistently faring better than defendants in detention. ABA Standards for Criminal Justice, Pretrial Release, 29, 3rd edition, 2007. That's where you can find that. That is even more likely to be the case here, where detention is stripping the defendant of any real opportunity to review the evidence against them or otherwise prepare for trial. For the foregoing reasons and to ensure a fair trial and protect Mr. Combs' constitutional rights, the court should order release on the proposed conditions or any other conditions the court deems appropriate. Did y'all see that teeny Garagos? That's my Garagos' daughter, I believe. We got Alexandra Shapiro. She's good with the appellate work. She does the appeals. We got Anthony Drico. He does like the high stakes criminal cases. Like he did a lot of capital cases. Anna Estaviveo, I don't even know who she is because that's the first time I have ever seen her. So he done added somebody else on the team because they all in different firms. You got Shapiro, Arado, and Bach. You got Agnafilio and Trader, law offices of Anthony L. Rico, and then you got Cher Traumatin. He said he got his own. Said Johnny Cochran is gone, but I created my own dream team. Let me see, attorney in New York, Anna Estavio. Anna represents individuals and entities in connection with complex criminal proceedings, internal investigations, and commercial litigation. Her clients benefit from the strategic advocacy and uncompromising dedication she brings to each matter. She went to the New York University School of Law. She was magna cum laude. She did law review. I did law review too, little known fact. She's admitted in New York, California, U.S. District Courts for the Eastern and Southern District of New York, U.S. District for the Court of Southern District of California, and the U.S. Courts of Appeals for the Second and the Ninth Circuit. She also clerked for the Honorable Denny Chin over there at the U.S. Court of Appeals for the Second Circuit, and the Honorable Vernon S. Broderick over there at the U.S. District Court of Appeals, Southern District. Her experience, she had a full acquittal in a federal weapons trial in the Southern District of New York. Other notable experience includes represented non-United States citizens charged with cyber stalking and extortion. She represented former law enforcement officer charged with transporting drugs. She successfully advocated for probation. She represented soccer leader in FIFA corruption scandal, successfully advocated for probation, and an enormous reduction in clients' restitution obligation. She represented a postal employee charged with conspiring to import and distribute synthetic cannabinoids into the Southern District of New York. She succeeded in having the charge reduced to a petty offense misdemeanor and obtained a sentence of 1 year probation. After an indigent client was charged with drug conspiracy, secured the client's enrollment in the Southern District of New York Young Adult Opportunity Program. She successfully opposed the government's request for over $13 million in restitution and forfeiture from a doctor in a healthcare fraud case. Okay, girl, I'm trying to see this trafficking. I don't see any of that in there. She is selected as a rising star in white collar crimes list by Thompson Reuters Super Lawyer. I'm in Thompson Reuters Super Lawyer too. So yeah, that is her background for those of you that even cared, but I'm just nosy like that. What do you guys have to say? He had a child from an entanglement. What y'all gossiping about? He gave Janice $1 million in a car for showing people at a Diddy party she could still do it. Some hands flat, Alex. What? Jesus. Now that Agnafilio, he represented, what is the name of that guy? Oh my gosh. Because I looked him up and I was like, Diddy, I don't know Diddy. Because that man got like 100 and something years. Let me see. He got a lot of years. I can't even think of the name. I saw it on American Greed and I looked the case up because that's just how nosy I am. And I was like, oh my gosh. You did a lot of time, bro. It was like the same. He was arguing a lot of the same stuff. That's why I was like, yeah, you got to come with some different arguments because that didn't work for the other guy. I can't find the name of that case, but it was an American Greed case. And I was like, ooh, goodness. Let's see if I can find this case real quick before we get off of here. Diddy. So what do you guys think? You guys think he's going to get off on, put a 1 in the chat if you think he's about to get out on bonds. Put a 2 in the chat if you think he's about to stay put. Let me see. I don't see it in here. I got so many cases on my desktop. This is just horrible. Oh, so it's kind of split. Okay. Not you one of one says 0. Child, that wasn't even an option. It's always got to be one that don't follow the rules. Always got to be one. I thought that would be 504. That would say that. Put some old random number in there. Can't think of I don't remember the name of the is this it? Sentencing memorandum. Sentencing memorandum is this. Oh, that's Whitehead's. I got so many cases on here that don't belong to me. That's somebody else's case. But anyway, I hope you guys enjoyed this super long, ridiculous, late live. Make sure you hit the like button. 504 say he's dangerous. It's the 313 in me. Shout out. What up, though? That's it. Dead brushing y'all off here. Good night, y'all. So y'all took enough time. All right, y'all, for real, I'm getting off here. This was very fun. We're going to have to do this again real soon. But until then, I'll holler at you guys next time.